that this proceeding is anything other than transparent. And so we'd ask that those sidebars, unless there's some compelling reason identified by the court,
Good morning.
Be live streamed as they will be on the record. Thank you.
Attorney Pattis.
I've never had a case where sidebars were made part of the public record. The purpose of the sidebars is so counsel and the court as
we'll catch up
can develop a shorthand to address issues that may be complicated and easily misunderstood by the public at large. It would be of assistance to me in trying a difficult case to have sidebars not broadcast to the world at large. Otherwise, I'll have to posture on behalf of my client, and as your officer, I'd rather just cut to the chase.
All right. I think on further reflection that
looks like we're good.
There's nothing said on the sidebars that can't be live streamed, and I think that I agree with the plaintiffs on this issue, so that we will live stream the sidebars. Most of the sidebar we just had was discussing the coffee setup in Mr. Ferraro's.
I'm going to explain this as we go along. They are seeming to be covering preliminary motions in the Alex Jones trial, which is, as it was in Texas, this is now in Connecticut with multiple plaintiffs, only on the damages because of the sanctions that have been imposed on Alex Jones, al, free speech systems, etc. And he got some more sanctions this morning, which we'll get to in a second. Just want to make sure the audio is acceptable. Bad mic. Okay, thank you. USB, you're correct. So I got the good camera. Just go to the good mic. Oh, yeah. There we go. So this is being live streamed. There does not seem to be any publication ban on broadcast or rebroadcast of the Connecticut trial. Unlike Texas, I had a disagreement with Nate as to whether or not one could rebroadcast someone who was broadcasting the trial when there was a rebroadcast ban in effect by the judge, order of the judge in Texas, not this time around. It looks like thus far today, the mic is the good mic now. Are you going to rumble again? I don't like it. Can't play in the background. I'm going to rumble in a bit. Audio's good. Good. Cover up the logo. Thanks for streaming. Let me see how I can do that. How can I do that? Let's see if we just go like this. No, I just covered it up entirely. Oh, how about no? Well, that's pretty good. Nobody cares if we see my ugly punum, or don't, I should say. I'm not your buddy guy. Oh, hold on. Maybe if I do it like this. Hold on. Actually, let's just do this. Let's tinker with this. That might be too small. If I go like this, no, that's no good. If I go like this, Barnes is coming in at some point, I think. If I were to do this, and then if I bring up a chat, all right, so I'll just leave chats up the entire time. I'm not your buddy guy says, I fear the left globally have embraced fascism, knowingly or not, and are doing a mental dress rehearsal for what they're about to do. I think he said something along those lines yesterday during the stream. We're now waking up to confirmation that 30 some odd plus subpoenas issued to 30 some odd plus of Trump's closest allies, including counsel, Giuliani, Jenna Ellis, like talking about fascism, talking about people not appreciating what they're embracing, foregoing the most fundamental privilege, constitutional rights, the right to an attorney. You have the right to an attorney, but if the Department of Justice says those communications are no longer privileged, the damage that is currently being done is immeasurable. So let's get back. We're going to have time to pause, I guess, or fast forward when the trial goes on pause or something. This morning, from what I've seen, I was a little late. Preliminary motions. There was a motion to sanction for the same reasons that we saw in Texas, this Google Analytics document that apparently the judge said Jones and the other defendants were cavalier in disregarding their discovery obligations. They didn't communicate this Google Analytics spreadsheet, aggregate data, whatever, when they were required to do so, which showed or would have showed that they did not make profit off their coverage of Sandy Hook. Apparently, default to do it, default to communicate it. From some of the representations of Jones's attorney, it looks like they might have known about this Google Analytics document or Google Analytics, whatever it is. Just so everybody knows, I'm a totally ignorant as to what Google Analytics are. I've never, in the life of my channel, looked at Google Analytics, Once upon a time, I was looking at Facebook analytics when I was running ads for my political campaign. I don't know what it is. I don't know what it looks like. I don't know what it tells you. I don't know how you access it. And I don't know how you access it or if you can after you've been banned from a platform. So I don't know. But it sounds like Jones had access to this document recently, relatively recently, was required to disclose it or whatever, didn't. And now, according to the sanctions from this morning, is precluded from arguing that he did not profit from his coverage. And I say he is in all the defendants of the Sandy Hook events. Let's see. We're just going to continue playing and pause periodically.
Office and
For which we are grateful.
Is that too loud?
and the Oreo cookies. So, all right.
Tell me if that's too loud, people in the chat.
Just give me one moment and I'll go through the language on the charge.
Okay, let's see what here they're going for. A charge sounds like contempt. Let's see.
I don't want to read. I have around a
Wow.
page and a half, so I think I'm just going to pull out the parts that may be of interest. So I'm going to instruct the jury that a civil trial such as this generally has two issues, liability and damages. In this case, however, you are only considering the issue of damages. Why is that? Because the court has made that determination for reasons that you need not concern yourself with and you should not speculate about. Therefore, liability is established and you are not to consider liability. Instead, you are tasked with considering damages, fair, just, and reasonable compensation for the plaintiff's injuries and losses.
These are
Then I have a couple paragraphs that you don't really need to hear, which are the agreed upon paragraphs that you gave me.
I presume these are the instructions to the jury
And then
as to what they're doing
the
there.
paragraph I think that matters to you is Alex Jones and Free Speech Systems are therefore responsible for two kinds of damages under Connecticut law. The first are called punitive damages, and these are determined by the degree of wrongfulness of the defendant's conduct. The court will determine the amount of punitive damages. The second are called compensatory damages, and these are intended to compensate the plaintiffs for their damages. I will give you further instructions on damages at the end of the case after the closing arguments. The parties categorically disagree on the amount of damages due. The plaintiff's position is that the damages due are substantial. The defendant's position is that only minimal damages are due.
Your Honor,
What are the chances
I think
they don't know about the
issue-
45 million out of
The key
Texas?
issue about the court will determine the amount of punitive damages. There's two kinds of punitive.
Yes, I realized that after I read it, so I'm very grateful that we just went through this process. So why don't you have a discussion with Attorney Pattis and give me some correcting language, or I can just delete that sentence. I can delete the sentence, the court will determine the amount of punitive damages. I just read that. I have a lot of scribble scrabble here.
Yeah, I think if the court deleted that sentence, and then,
I don't think I even need to add anything else if I just delete that sentence.
right.
All right.
So I think with that deletion, we're okay.
No, with that delusion, that's
All right, so just timing wise, I know that you'd all like to take a 5-minute, did you have something else, Attorney Sterling?
I'm sorry, Your Honor.
Did you have something else or no?
No, Your
okay.
Honor, I was whispering and I forgot to sit down.
That's all
Thank
right. Just time wise, how do you want to proceed? So I would say my comments are probably maybe 5 minutes, maybe 10 minutes, if that. So that would bring us, I suppose we could take I don't really want to take the morning recess now, but if that'll take us till around 11.
hurry up and wait is what court is about.
We usually take the afternoon recess at 11:30, right? So how do you want to proceed with your openings? I hate to sort of interrupt them, but I'm just trying to figure out when we should take the morning recess. I don't want to break up your flow.
I think certainly, yeah, I would not want the court to break up my opening.
No, I don't mean break
Right,
up.
so I defer to Attorney Pattis as to whether or not he'd want to take a break or continue on.
Attorney Pattis is Jones's attorney.
Let's take the break now and then get the closing arguments done as a block and then come back for evidence.
Opening.
Yeah, sorry,
We're not closing yet.
I got that. And it wasn't the afternoon recess.
I saw yeah. All right. So why don't we take a brief recess? We'll bring down the panel and we will be back shortly.
All right. Well, let's see here. That's going to be, they're going to live stream the sidebars. How is that going to work? I thought the whole issue about a sidebar. Let me just see where we are if we go back to live. Yeah, they're in recess. So we're going to take this out of the stream. I thought the whole issue about a sidebar was so that the jury doesn't hear what they're discussing, so as not to influence the jury on a disputed issue, not so that you can live stream the sidebar and then hope the jury doesn't hear it. Wait a minute. Viva Fry, so what was the reason for the default? Why does Alex get denied trial on the merits? The explanation is that the official explanation, this is not my agreement or disagreement, is that Alex Jones allegedly repeatedly defaulted on disclosure obligations, failed to communicate documents he was required to communicate, failed to comply with discovery obligations in terms of, saying that he looked for text messages about Sandy Hook and didn't find any. And then, allegedly there were text messages that he ought to have turned over. Basically, simply put, Alex Jones failed to comply repeatedly. And as this judge said, in a manner that was cavalier, failed to abide by, respect obligations under discovery. And therefore, was precluded from defending and had the ultimate sanction of ultimate sanctions, a default verdict rendered against him. This is where we'll have disagreements with people who say, just comply with discovery obligations and you don't have the problem. And you'll have, Robert Barnes makes the argument that few people, maybe there's more, it's hyperbolic, but Alex Jones sat down for repeated discoveries, communicated millions of documents, emails, opened, unopened, turned over servers, turned over inboxes, junk mail with emails that hadn't been turned over, arguably everything. But some people say, well, you can turn over 9,999 documents, but not turn over the one. And it'll ruin everything. It'll destroy the file. It'll make it impossible for the plaintiffs to pursue their case effectively. The reality, and I'm speaking from a Quebec law perspective, but it's the standards are similar, is that you can get foreclosed from pleading, which is the ultimate sanction. It's to say you cannot defend anymore. And even then, however, even when you're foreclosed from pleading, you cannot defend. The plaintiff typically still has to prove their case. It's not even an analogy. This is a comparison. You have a contractual dispute, and the defense would have been, I never signed that contract. That signature is a forgery. Okay. You behave so badly. You shred the documents. You burn computers. You smash cell phones with hammers. Use bleach bit to wipe things. You behave so badly, you make it impossible for the plaintiff to effectively pursue their case by destruction of evidence. You get foreclosed from pleading. Bad boy, not even a slap on the wrist, the ultimate sanction, you cannot defend. It doesn't mean as though, victory by default. Nonetheless, the plaintiff typically still has to come to court, still has to prove to a judge, here's the contract, here's the plaintiff's signature, here's the defendant's signature, and they still have to submit the evidence that a judge or a jury then says, okay, you've proven your case even in the absence of a defense. Default, as though the defendant was not there. Defendant says, I'm not even coming to trial. Go do your evidence without me. Piss off. Make your evidence. If you can make your evidence, I'm not even going to contest it. But you still have to make your evidence. You still have to prove the case. In theory, typically. Unless what happened here is they got a verdict by default without even having to, prove the elements. The judge says, okay, well, Alex Jones behaved so badly, you win. You don't even have to prove it. default verdict. You don't even have to come to court and prove that the statements were made about you, that you were identifiable, that they were made within the requisite time frame. No, don't even have that. It's just verdict by default. And that's what happened to Alex. It happened in Connecticut. And then what ended up happening, from my understanding, is he got a similar verdict by default in Texas, because the Texas judge was relying on the alleged cavalier egregious default in other jurisdictions to support the verdict by default in her jurisdiction, that being Texas. So that's it. That's where that's what's going on now. So we had the trial on damages alone because of the verdict by default, or the default verdict in Texas, and we have a similar thing in Connecticut. Texas, what do you want? Had two plaintiffs. Texas had two plaintiffs, and Connecticut has more than two plaintiffs. Your breath smells. Verdict by default. But it's not even. It was a verdict by default, which is, it's beyond the ultimate sanction. And then they proceeded to a trial on quantum only, with instructions to the jury. He's already been found guilty on the merits. We are not here to contemplate his guilt. His guilt is proven by default verdict. His guilt has been proven. Now it's just a question of how much does he have to pay? And his defenses, even on the trial on the quantum alone, were ridiculously limited. I don't know if anybody was watching the Texas case. Ridiculously limited in that he could not raise the fact that he apologized. He could not raise the fact that he issued corrections, that he didn't intend to cause emotional distress. He was limited from presenting evidence of mitigating factors in the trial on the judgment on the quantum alone. So I mean, I don't know who can think that this is how the judicial system is supposed to work. I was involved in a case. Okay, get down here, annoying me. Oh, I was involved. Remind me to tell you about Pudge waking me up now at exceedingly early hours for food. I'll get there in a second. I was involved in a case. It's all public, but I'm still going to be very vague on the details. It's all public. It was an American who had a massive verdict by default rendered against them in the States, like in the orders of hundreds of millions of dollars by default. Similar sanctions to Alex Jones, precluded from even defending because of how egregious, allegedly, the court conduct was. They got a judgment by default in the States, took it to Canada, homologated it in Canada, which has had it recognized by the court, to seize assets in Canada. And Canada said, look, we don't issue judgments by default of this magnitude, of this quantum, as a rule. This would be violating our fundamental rules of justice to have a $100 million default verdict in the States brought over to Canada, homologated as though we would have ever issued such an order, and as though we would have ever possibly issued it in such a quantum. And it led to a whole bunch of things, but that was the first time in my entire life I'd ever seen a default verdict. And the conduct, I mean, I'm not going to get into whether or not the conduct was bad or good, whether or not it was foreclosed from pleading. I mean, there is no greater sanction. It's the death penalty of law. What do you have to do to get the death penalty? Well, it's got to be pretty bad, and it's got to be pretty clear, and it's got to be pretty unequivocal. I was involved in cases where you actually had witnesses or parties destroying evidence, refusing to. Okay, fine. You get a sanction. You get contempt, civil contempt. Court seems to be back in. Okay, we're back in session here. Let's add it. Let me just bring in.
Are not entitled to punitive damages as a matter of law, that nothing in the default grants that's a legal question, and whatever material facts are deemed admitted as a result of the default, they don't reach to the question of punitive damages. That's at best a mixed question of law and fact, perhaps a question of law. So I say no.
You're going to move for a direct verdict on that issue as well, correct?
Correct. Yes.
Oh, I guarantee the judge is not going to.
I just wanted to preserve that.
Certainly.
And Your Honor, just on that the issue that we raised at Sidebar, all of the exhibits that I listed earlier today which have been agreed upon. I can't recall if the court formally admitted them as full, but if you could just put that.
So ordered.
Thank you.
Anything else before we bring the panel out?
Not from the
Panel of
plaintiff.
judges. All right.
No,
All right, so the game plan is I'll do my introduction and we're gonna go through both your openings and then take the morning recess, correct?
the lunch recess, I presume.
Maybe.
That's fine.
Well, what are the
If
recess going to be?
something
It's 11
changes,
o'clock.
Attorney Pattis, and you need a break after Attorney Maddie opens, you just let me know.
So
okay?
Madden is Jones, Pattis is, no, sorry, Mattis is plaintiffs, Pattis is Jones. How is the audio balance between me and the court? Let me know in the chat. I'll be following the chat in Rumble as well. I hope they know that we can hear them. Okay, I'm watching the chat in Rumble as well. We got a $5 Rumble rant says, once again, I'm not seeing Neria Taco in sight. Self-loathing lib. Second Amendment or die says Keith Hutchins is chanting lock Viva up. Don't worry about it. You can ignore. Volume is good. Good. Morning. All sounds fine. Okay. So there's going to be one more, it looks like, preliminary motion on whether or not the plaintiffs are entitled to punitive damages as a matter of law, and then opening statements, I guess. And I'll see how long we keep this live on YouTube for. I'm reading the chat, and seems to be a dog here. Let's see if we can hear something good. It is interesting. You don't know what the judges are like when the cameras are not live streaming a trial, but they definitely seem to have a demeanor when they know that this is being live streamed for the world to consume in real time. So Alex Jones is already guilty in this trial too. Yep. No, this was the precursor to the default judgment in Texas. I'm fairly certain the Texas judge relied on the default in other court filings, in other court cases, to come to her finding of default as well. Good morning, Jamie Lee McFadden. Normal-minded people like Viva. Normal-minded people like Viva, or normal-minded people like Viva. Or normal-minded people like Viva? I'm joking. Okay, so what's going on?
Good morning.
So now they're bringing up the jury.
Good morning, welcome.
They are.
Good morning. Good morning, ma'am. Good morning. Still morning, I think. Welcome. Sir,
That joke never
welcome.
gets old.
Good morning. Good morning.
Declaring bankruptcy
Make
and
yourselves
starting a new
as comfortable
business
as possible.
will not
Mr. Ferrara will do the roll call.
will not
and
resolve
he'll
anything.
Swear in our 6 regular jurors and our 4 alternates.
Okay, so it's a jury trial and it's 6, I guess, in Connecticut.
First, for the regular jurors, when your name is heard, please enter here, rise, and remain standing.
Okay, did the audio just go from one side to the other, or am I having an aneurysm? Okay, now they're muting out the audio so that we don't hear the names of the jury. That makes sense. Alex needs to declare bankruptcy and start a new business. Let me tell you something. I know I don't look like a standard lawyer, but I also did a lot of bankruptcy, and I had one file that went on for years. Declaring bankruptcy is not a solution to certain problems. It's actually just another can of worms that you're opening. When a corporation, an entity, an individual declares bankruptcy, it exposes them up to basically a forensic audit as to whether or not they made any preferential payments, whether or not they took excessive salaries to the detriment of creditors. It allows for a full bending over and a full body cavity search of the corporation. Tina Brevard, welcome to the channel.
Same thing.
Newbie at Viva is an awesome stream. Why, thank you. Yeah, they can go into preferential payments. They can go after the individual to say that they were conducting business knowing that they were insolvent. It's a can of
You'll
worms.
decide this case between the plaintiffs and defendant based on the evidence given in court and on the laws of the state as explained by the judge. that we will not talk to each other about this case until instructed to do so, that he will listen to and consider what the other jurors have to say in deliberations about this case, that he will not speak to anyone else or allow anyone else to speak to you about this case, and that when you reach a decision, you will not disclose the decision until it is announced in court.
Well, until the decision. The decision is only how much now. It's not even if. It's how much.
Ladies and gentlemen,
let's see
as
this.
you may recall, I'm Judge Bellis. We are starting trial in the civil case of Lafferty versus Jones. And I ask for your indulgence as I have to read to you some opening remarks. Please listen carefully as I read these very important preliminary instructions to you. As I said, we're about to start the trial of a civil case, Lafferty versus Jones. The party who brings a lawsuit is called the plaintiff. Here, the plaintiffs are Robert Parker, Erica Lafferty, David Wheeler, Francine Wheeler, Jacqueline Barden,
So that's 6,
Mark Barden,
7,
Nicole Hockley,
8,
Ian Hockley, Jennifer
9,
Henzel,
10.
Donna Soto, Carly Soto Parisi, Carlos Matthew Soto, Jillian Soto Marino, William Aldenberg, and William Sherlock.
So how many is that?
The
Like
party
16
against whom
plaintiffs?
the suit is brought is called the defendant. Here, the defendants are Alex Emmerich Jones and Free Speech Systems, LLC.
And that
Now,
feedback
you
is annoying.
just took an oath that will govern your conduct as jurors between the time you take that oath and the time that you are discharged by me after you have rendered a verdict in this case. That oath and the rules of court obligate you to do certain things and to avoid other things. These are called the rules of juror conduct. You were given a copy when you were selected as a juror. Because they are so important, I need to review these with you again.
Important.
First, you must decide this case based only on the evidence presented here in court and on the law.
It's
as I
only
will
on
explain it to you.
only on quantum.
Second, do not make up your minds about what your verdict will be.
He's already guilty.
Until after you have heard all the evidence.
He's already guilty.
The closing arguments
legally.
of the attorneys and my instructions on the law. And after that, you and your fellow jurors have discussed the evidence.
Oh, God,
Keep an open mind until that time.
Keep an open mind. Guilty.
There are some rules that
guilty.
flow from these obligations, and I'll go over them now. You may not perform any investigations or research or experiments of any kind on your own, either individually or as a group. Do not consult any dictionaries for the meaning of words or encyclopedias or Google for general knowledge on the subjects of this trial. Do not look up anything on the internet concerning information about the case.
I'd love to know the jury questionnaire.
Including the parties,
see if I can
the
find
witnesses, and the lawyers. Do not get copies of any statutes that may be referred to in court.
I will not make fun of her accent, but it's kind of Connecticut.
Why? Because the parties have a right to have the case decided only on evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we don't know about, then your verdict may be influenced by information that has not been tested by the oath to tell the truth and by cross-examination. The same thing is true of any media reports you may come across about the case or about anyone connected with the case. If you do come across any reports in the newspaper or on magazine or on TV or on internet or on a blog, you may not read or watch them because they may refer to information not introduced here in court, or they may contain inaccurate information.
Oh.
You may not discuss this case with anyone else, including anyone involved with this case, until the trial is over and you've been discharged as jurors. Anyone else includes members of your family, your friends, your coworkers. If you wish, you may tell them that you are serving as a juror, that you may not tell them anything else until I have discharged you. You may not talk to any of the court personnel, such as marshals and clerks, about the case.
Feedback is not mine. The feedback is in court.
Because they haven't heard the evidence you have heard, and in discussing the case with them, you may be influenced in your verdict by their opinions, and that would not be fair to the parties, and it may result in a verdict that is not based on the evidence and on the law. You may not communicate to anyone any information about this case. That includes any means, such as text messages, email, internet chat rooms, blogs, social media websites such as Facebook, YouTube, Twitter, TikTok.
Long Island.
The parties are entitled to a fair trial rendered by an impartial jury, and you must
This all
conduct
seems
yourself
somewhat
so as to
academic
maintain
since
the
he's already been
integrity
found
of the
guilty
trial
by
process.
verdict,
When
default
you
verdict.
have rendered a verdict and have been dismissed by the court, you will be free to discuss the case with anyone you wish, though remember, you are not required to. Until then, you must be focused solely on the evidence presented in the courtroom and your obligations to the fairness of the proceeding. In addition, you may not talk to each other about the case until I tell you you can do so.
Wow.
And that will not be until you've heard all the evidence, you've heard the closing arguments of the attorneys, and you've heard my instructions on the law that you are to apply to the facts that you find to be true.
I don't know
Why
if it's
is
my
that?
bias.
It may seem only
find this-
natural
I
that you
find
would
this
talk about the
patronizing.
case as it's going on. The problem with that is when people start discussing things, they take positions on them and express opinions, which are often hard for them to change later on. So if you were permitted to discuss the case while it's going on, you might reach conclusions or express opinions before you've heard all the evidence or heard the final arguments of counsel or heard the law that you must apply. Your verdict in the case might then be improperly influenced by the conclusions
I love how
or
she's
opinions
talking
you
about
or your
making
fellow
sure
jurors have reached
the verdict is
before
not
you knew about
improperly
all of
influenced.
the evidence or the law that will help you put that evidence in the proper context for your verdict. What happens if these rules are violated by a juror?
Oh, tell us.
In some cases, violations of the rules of juror conduct have resulted in hearings after trial at which the jurors have had to testify about their conduct. In some cases, the verdict of the jury has been set aside and a new trial ordered because of jury misconduct. So it is very important that you abide by these rules.
Important. That's the very interesting
If
word.
someone should attempt to talk to you, please report it to the clerk immediately. If you see or hear anything of a prejudicial nature or that you think might compromise the proper conduct of the trial, please report it to the clerk immediately. These communications with the clerk must be in writing. And do not discuss any such matters with your fellow jurors. For those of you who are presently serving as alternate jurors, all these instructions apply equally to you, as in the event that one of our regular jurors becomes sick or otherwise incapable of serving, under our law, the regular juror will be replaced by an alternate juror. Those of you who serve as alternates play a crucial role and may be called upon to replace a regular juror at any time. Now, it's useful for you to know what the various parts of the trial are so that you may be aware
you've missed
throughout the
nothing.
trial
Preliminary
what
motion,
stage of the proceedings is in
sanctions,
process and what comes next.
sanctions for
the
failure
trial
to
starts
comply
with the
with
opening
discovery.
statements by the attorneys.
Here, listen to
They
this.
will state the nature of their factual and legal claims. Opening statements are not proof or evidence.
Why, thank
They
you,
are
Sergeant.
merely statements of the claims of the parties so that you will be aware as you hear the evidence of what legal claims each party is trying to establish through the evidence. After the opening statements, the plaintiffs will present their evidence by calling witnesses.
On what?
The
On what?
lawyers for the defendants may cross-examine each witness.
Unless they're not allowed
After
cross-examining
the
on
plaintiffs have
certain
presented
issues.
all of their witnesses, the defendants will have an opportunity to present witnesses if they choose to do so. Any witnesses presented by the defendants may then be cross-examined by the plaintiff's lawyer. Once all of the witnesses and evidence have been presented, the lawyers will make closing arguments to you. These closing arguments, like the opening statements, are not evidence. The final step is that I will tell you what the legal principles are that apply to the claims that have been made and the evidence that has been presented. That instruction is known as the charge to the jury. Your function as jurors is to determine what the facts are and to apply the rules of law that I give you to those facts. You are the sole and exclusive judges of the facts.
The facts that I allow you to
what
see.
Evidence is acceptable. You must make your own evaluation of the testimony given by each witness and determine the weight you choose to give to the testimony. You must use all your experiences, knowledge of human nature, and knowledge of the motives which influence and control human nature to test the evidence in the case and to render your verdict accordingly. Now, a civil trial such as this generally has two issues, liability and damages.
Generally.
In this case,
No
however,
liability.
you are only considering the issue of damages.
Oh, why is that? Why is
Because the court has made that determination
for the jury
for reasons that you need not concern yourself with,
of course not.
and that you should not speculate about.
Oh, okay. Oh, just the judge said guilty?
Liability is established, and
Bypass
you are
the
not
jury.
to consider liability. Instead, you are tasked with considering damages.
See if I can go.
Alex Jones is the principal of a for-profit corporation known as Free Speech Systems. After the Sandy Hook shooting happened, Alex Jones and Free Speech Systems stated that the Sandy Hook shooting was a hoax, that no one died at Sandy Hook, and that the families of the victims were actors.
She's giving this as
Mr.
evidence.
Jones used multiple channels to distribute these statements to his audience,
This is amazing.
including the Infowars family of websites, Mr. Jones' nationally aired radio broadcasts, and social media. You will hear more about the defendant's business practices during the evidence in this case. Now, as I've mentioned, this is a hearing in damages. Alex Jones and
it's a
Free
hearing in
Speech
damages,
Systems are liable
but she
under
just
Connecticut
gave
law
a summary
for
of
defaming the
her
plaintiffs, casting the plaintiffs in a false light, resulting in an invasion of their privacy, intentionally inflicting emotional distress on the plaintiffs, and violating the Connecticut Unfair Trade Practices Act, which prohibits unethical, immoral, and unscrupulous business practices resulting in damage to the plaintiffs. Alex Jones and Free Speech Systems are therefore responsible for two kinds of damages under Connecticut law. The first are called punitive damages, and these are determined by the degree of wrongfulness of the defendant's conduct. The second are called compensatory damages, and these are intended to compensate the plaintiffs for their damages. I will give you further instructions on the law of damages at the end of the case after the closing arguments. The parties categorically disagree on the amount of damages due. The plaintiff's position is that the damages due are substantial. The defendant's position is that only minimal damages are due.
Why is she
It
saying
will be
this?
for you to determine these issues as I instruct you based on the evidence you will hear and the instructions I will give you.
Let's hear what she has to say about whether or not they agree on the guilt. Are they allowed to say they disagree on the guilt?
It bears repeating.
Oh, let's hear it.
You must wait until you have heard all of the evidence and have heard my charge to you on the law that applies before you make up your minds about any issue in the case. The evidence upon which you will base your decision will come to you from the witness box or in the form of photographs, documents, or other exhibits introduced during the trial. And again, and I'm repeating this, you may not begin to discuss the case even with each other until after you've heard the charge on the law, because your duty is to wait until you've heard all of the evidence and the applicable law before making up your minds and discussing the claims and issues.
There are no claims and issues. He's guilty. Now it's just how much.
The parties may or may not be present in the courtroom during each day of trial. Absence from the courtroom is permitted unless a party is under subpoena to testify on a particular day. In general, I instruct you to draw no inferences for or against any party based on the presence or absence of that party. If a witness is absent on a day when they are under subpoena to testify, I will instruct you further. You may also notice that on some days, some counsel may not be present. I instruct you to draw no inferences for or against any party based on the presence or absence of some of their counsel on any given day. As in most trials, only the lawyers and at times the judge asks questions of the witnesses, and the jurors do not have any opportunity to ask questions. However, you may, if you wish, take notes during the course of the trial. We will distribute notepads after the opening statements. When you receive them, you will write your name on the notepad if you are interested in taking notes, and they'll be collected during each break and during the lunch recess and at the end of the day.
Facts that she
Some
gave,
jurors
the facts
find
that
that
she gave the
taking
jury
notes is
and the
helpful in
facts that she
keeping
omitted.
track of the proceedings, and some do not. You should remember that your main job as jurors is to listen to and observe the witnesses. If taking notes would distract you from that job, then don't take notes. There is no need to try to take down the testimony word for word. If during your deliberations at the end of the case, you need to hear what a witness said, we have an official tape recording record that will give you an accurate record of all that testimony. You should not allow note-taking to interfere with your attention to the testimony or your task of sizing up the witnesses as they testify, but you may take notes if doing so would aid your memory.
Thank you very much.
You should not make any notes outside of court and bring them here. As I said, your notebooks will be collected at the end of each break and kept secure by the clerk. No one will look at your notebooks. I take notes because I may be asked to rule on issues during the course of the evidence. Your decision whether to take notes at any point should not be influenced by my note-taking.
Don't be influenced by
You should not disclose your notes to anyone else during the trial. It will be up to you to determine whether to disclose them to your fellow jurors during your deliberations at the end of the trial. I just want to briefly go over the schedule again. As you will recall, on the day you were called in for jury duty, you were required to be at the courthouse 8 or 8:30. During the trial, generally speaking, you will be required to be here Tuesday through Friday from 10 a.m. to 5 p.m. We always have our lunch recess between 1 p.m. and 2 p.m. And we generally have a 15-minute morning break and mid-morning and a mid-afternoon break. If there's any change in that schedule, I will let you know. And as we told you during voir dire, we expect that the case will last approximately 5 weeks through mid-October. Now, with respect to the breaks, if at any time, even this morning, anyone needs a bathroom break, just simply raise your hand. We're not going to have a situation
they would be
where I can
kicked off as a jury member and replaced with an alternate.
If someone raises their hand, that means that we need to get bathroom break, and we'll always be happy to take a quick 5-minute bathroom break. During the course of the trial, you cannot have any communications with me except in open court on the record. So if there's some issue, such as a sudden issue occurs while the trial is in progress, you should write a note, give it to Mr. Ferraro, and then he will give it to me and I will respond on the record if need be. If some emergency occurs when the court is not in session, you should call Mr. Ferraro, whose phone number was on that sheet of paper that you were given when you were selected, and indicate what the problem is. Obviously, since you've been selected as a juror, it is your duty to be here every day that the case is on trial, on time, and you can imagine the inconvenience to everyone else if a juror fails to be here punctually. In the unlikely event, however, that there's some emergency, I just described the process.
Don't worry about it. We can figure it out if there's an emergency. Get to the trial. Get to the trial on damages only. He's already guilty. So you don't need to think about that.
Said, I think several times now, under our rules of juror conduct, you must not speak to anyone about any aspect of this case while it is in progress.
At least.
Mr. Ferraro will go over with you the certain routes that you'll take to the courtroom to avoid contact with parties, witnesses, counsel, and the media. While the court staff and I will greet you and give you any necessary instructions, we are not permitted to talk to jurors about a case while it is going on. And similarly, counsel are bound by a rule of professional conduct that forbids them from having any contact with jurors during a trial. So please don't hold it against any party or any attorney that you might see in the building, because they don't know to maintain their distance from you and not to converse with you.
Don't be offended if nobody talks to you in the hallway.
So you will recall those instructions that you were given on the day that you were selected, that you read and signed and brought home. There's one paragraph in particular that I want to go over again.
He's guilty. Don't forget it.
And I'm just going to read right from the form again.
He's guilty.
If you are exposed to any publicity or communications, despite your best efforts to follow this instruction to avoid it, you must immediately inform the court about the exposure in writing without advising any of the other jurors about that fact or about the nature of the exposure, so that the court can follow up as necessary to protect the party's right to a fair trial. If this exposure occurs when you are in the courthouse, you'll write the note, you'll give it to Mr. Ferraro. If this exposure occurs when you are not in the courthouse, you'll contact Mr. Ferraro at the number he provided.
Am I a pervert, or when you say—
Please follow the same procedure if you believe that another juror may have violated any of these rules of juror conduct. So again, don't speak to other jurors or reveal any specific information to anyone, but immediately advise the court of the event and await further instructions. I will tell you, this is so important to the court that I will be reminding you after breaks every morning at the end of the day. And I ask for your patience in that regard, but I want to make sure that we avoid any issues, particularly with exposure to the media. But your obligation is, of course, to advise the court through Mr. Ferraro immediately if you were unable to avoid any such exposure. It must be brought to the attention of the court through Mr. Ferraro and not discussed with your fellow jurors.
I hear the word exposure, I immediately think it's something else.
If there is anything that any of you need for your comfort at any time, you'll let Mr. Ferraro know, and he will do his best to accommodate you. I saw a couple of you brought some water out. You're more than welcome to bring cups of water out or whatever beverage you'd like to bring. If any of you would like us to set up a water pitcher and some cups maybe on one of those chairs,
we get it.
To do that. I don't want to disrupt the trial, but I want to make sure that you have the same opportunity to drink your water that the rest of us have. So unless anybody raises their hand for a bathroom break, we are now going to proceed to the attorney's opening statements.
Two brief housekeeping issues. May we approach?
Certainly.
They're going to live stream a sidebar. Let's see how this works.
So this sidebar will be brief, and there will, throughout the trial, be occasions to have sidebars. There will also be occasions throughout the trial that the court will have to discuss objections, where you actually may be asked to leave the courtroom during the objections, and you certainly are not going to hold it against the attorneys or the court, because it is just part of the normal process. And it
this
actually
is
makes things much more efficient.
Yeah, okay. I was going to say,
I thought I heard the court say that I reached 8:30. Are we starting at 10?
Oh, no.
You said you
I thought I heard you say we're starting at 8:30. We're starting at
They've already
10.
arrived, so
Yeah.
Judge, our corporate rep has not been given a seat in the courtroom. Can she sit at our table? We discussed it.
The courtroom rep
Yes.
has not been given a seat
She's not going to be here throughout
in the courtroom.
She's scheduled to testify today. She's going to be here for today.
The corporate rep is testifying today.
I wanted to pick my heels to die on, but the marshals asked to leave because there aren't seats. We didn't get the seats we thought we were going to get.
That's fine, Judge. Whatever you like.
Okay, thank you, Judge.
This is
How do we
so
do that?
bizarre to be live streaming the
Do you need
sidebars.
an extra chair?
Yes. Well, can she sit at our table, or do you want her
Yeah, you don't have a,
whatever you want?
that's fine. Thank you, Attorney Maddy, thank you.
It's so bizarre to be
So
live
just an
streaming.
important clarification in all the instructions that I gave you. Normally, we start at 10. We actually started today at 10:30 because we actually were here bright and early going through different motions. But generally speaking,
What's up with
you'll
the
have
ring?
a 10 a.m. start.
And an
okay?
Apple Watch.
So you'll want to be here. You don't want to have to rush, and we can't start until you're all here. So you'll want to get here, 9:30, 9:45 at the latest, settle in. And again, we take our lunch always 1 to 2, so you can plan around that. And I generally like to end the day no later than 4:45. If we have a witness who's out of state, maybe we'll go to 5. We don't go after 5. And depending on where we are, we may even end a little early one day. So there's a little bit of flexibility involved. Okay? All right? So Attorney Maddy, whenever you're ready, please.
Thank you, and good morning, Your Honor.
Now we're opening statements. Not part of the evidence. And so the sidebars, I've never seen them live streamed. They've always been muted.
Thank you for being here. I'm sure everybody's relieved you're not going to have to be here at 8 o'clock every morning. Let me first
Opening
introduce
argument.
myself. I remember most of you from jury selection. I wasn't there every day, but my name is Chris Maddy, and I represent the families that have brought this case. I'd like to introduce you to the folks who are going to be here throughout the trial. Here at the table with me is my law partner, Alan Sterling, my law partner, Josh Koskoff. Behind me, Koskoff is Matthew Blumenthal, who's going to be here most days. And probably the most important person on our team, you also remember from jury selection, is my colleague, Pratika Seshadri. And she'll be displaying all of the exhibits for us throughout the trial, making sure we're well organized. Judge Bellis also mentioned the names of the families that have brought this case. They're here in the courtroom today. I'm not going to introduce them all by name, but I would ask that if you are a part of the family that has brought this case against Alex Jones, I'd ask you to please stand during the seat. Thank you. Thank you. So when we met in jury selection, I said to most of you that it was kind of an unusual way for us to meet, with the microphone and the judge and the huge courtroom, and we're trying to get to know you. And you probably walked into this courtroom today and feeling nervous and a little bit bewildered by even more of a formality. A bigger courtroom, screens all over the place. We got people, we got cameras. And what I want to say to you is that when you put all of that aside, put all of it aside, all we're here to do, all you're here to do.
This is acting in a good way. I mean, this is a lawyer's
common sense and your life experience.
Common sense and life
to come
experience.
together as a community, which is what you are, representatives of the community, to hold Alex Jones accountable.
Well, he's already been held accountable. Just make him pay.
Hours, days, the months, and the years after the worst thing that ever happened to this community. And when you speak at the end of this case with your verdict, you'll be speaking on behalf of the community. And you may not know this now, but you have everything you need to decide this case.
Yeah, it's already been decided for
your
you.
life's experiences,
Put some money on it.
the hardships you've been through, the tragedies you've been through, knowing what it is to live as a human being in the world.
This is the Connecticut trial.
What your parents taught you, what your grandparents taught you.
Last month was the
To know the
Texas trial.
difference between right and wrong. To know the difference between the truth and a horrible lie. To know the importance of standing up to bullies when they prey on people who are helpless and profit from them.
Profit from
And
this.
to know that unless you stop a bully will never stop himself. And when it comes to stopping Alex Jones, that will be the most important work that you do here. And we're all here because of him, one man, Alex Jones. I'm going to be displaying some slides
They're
here
here
throughout the presentation.
They're here because of
This
one
is
man,
Alex Jones.
Alex Jones.
And this is his company, Infowars. We'll be referring to it as Infowars throughout the case, but it's free speech systems. They're the same thing. And over the past 20 years, Alex Jones has built a media and business empire from his studio in Austin, Texas. Didn't always look like this. And Infowars revolves around Alex Jones, his personality, and this simple idea that he's been pushing for 20 years, which is designed to elicit fear and anxiety and paranoia and anger in his audience.
Just replace the word Alex
And
Jones
that
with
simple message is
CNN
this.
and see how this sounds to you.
That there is a global plot of financial and media and political elites, including in our own government, who are plotting to establish a one-world tyrannical government to enslave and kill people. That's the message. And he's been pushing it for 20 years. Now, to you and me, that may sound a little bit out there, but to his audience, an audience that he has spent years amassing, it is very real and very scary. The centerpiece of the Infowars programming is a website and a radio show, Infowars.com, and his radio show. Now, when Alex Jones first started, the Alex Jones Show was a radio show that was on 5 days a week, live, 4 hours a day. It started in Austin, Texas, got picked up and syndicated nationally to over 200 radio stations.
Replace the word Alex
And you
Jones
realized very early on
with
the power
CNN or
of the
MSNBC.
the power of the internet to spread the types of outrage and anger that he was spreading. That's why he started his website. And he realized that if you filmed the radio show, if you filmed it, you could post the video of it. And people could see Alex Jones' antics and just how angry he was and just how fearful his audience should be. And so he started live streaming to the internet at Infowars.com. He started a news site, okay? It wasn't a news site. In fact, you're going to hear Alex Jones himself and his corporate representative tell you that they're not journalists. And everybody knows they're not journalists, except guess who? Their audience, who they tell repeatedly that they are journalists.
Okay.
And so they start this website, and they put up all the different ways that the audience should be afraid of what's happening. Because on his show, what he does is he latches onto events in the world and uses them as examples for why the audience should believe him, that there is a plot unfolding to enslave and to kill them. Started growing. Infowars.com doubled to become prisonplanet.com. He added another website, Prison Planet TV. That's where you can watch all his videos if you wanted. And right before the social media revolution happened, what you have to understand is that Alex Jones was perfectly positioned to take advantage of exponential growth that social media would allow. Because he had a ready-made audience that was buying into his stuff. He had the type of medium that was most easily spread and engaged with.
I'm not confident,
videos.
Darren.
He had learned that he could clip his show into little segments, little digestible videos that would take off online. And so when Facebook came around, he went all in on social media. You just look at how many social media accounts he had on Facebook, on Twitter, on YouTube. YouTube, the perfect medium for Alex Jones to just put up little videos, and he encouraged his audience to share them. He started live streaming his radio show, which he was filming,
Live
to
streaming.
YouTube,
My
to
goodness.
Facebook,
He
and
didn't,
to his own website.
he didn't go
And
through the
his
networks
audience
like
was
CNN.
growing like crazy. Some of you in jury selection said you'd heard of Alex Jones. Others of you hadn't. But what you will learn in this case is just how influential he became. I want you to take a look at this slide here. This is from Infowars' own internal data. These are the numbers just for Infowars.com, his website in 2011, okay? Not Facebook, not Twitter, not YouTube, just his one website. Nearly 250 million page views in that year alone. 32 million users, 85 million sessions. This is the audience that he had amassed that were tuning in every day. And what they were tuning into was Alex Jones telling them that, had you heard about that latest famine orchestrated by the global conspiracy that's coming after you? Have you heard about chemical pollutants in our water and our food? They're intentionally doing that to kill you off. Have you heard about
Does
the
this
latest
guy not
pandemic
know about Flint, Michigan?
intentionally released upon you to depopulate you? Have you heard about falling fertility rates? The government trying to lower your sex drive so you have fewer children.
Has he not been
Have you heard
following
about mass
Bill
shootings?
Gates? My
Government
goodness.
operations as a pretext to take away your guns.
It's funny, you could describe the same
Every
thing
day,
and make it sound
something you need to be
preposterous
afraid of.
versus
And you're
making
going
it
to hear
sound
about this business model. This business model, though, depends on one thing, and that is an endless thing for people to fear. And he grew his audience, for one reason, so that by the time they came to his website, he could send them to his store where they could buy stuff. This is Timothy Fouget. He's a longtime business manager for Alex Jones. You're going to see his deposition played in this case. And I asked him, and in fact, you know that during the years, let's just say from 2012 onward, Mr. Jones' social media audience expanded dramatically year over year over year, correct? Yeah, that makes sense, yes. And as we've been talking about throughout this deposition, that expanded audience led to expanded revenue for free speech systems and Mr. Jones. That's correct. You can hear Mr. Jones's father, David Jones. testify about how they would connect what they were covering in the news to the products they were selling people.
Oh, God forbid they should sell. So do
I've
that with
observed, for example, if
pharmaceuticals
people are
on
being
Fox
stressed
News.
out about the idea of there being very dangerous flu things out there and stuff, and we have found that there is a product that is licensed by the FDA. Now, bear in mind, they don't carry FDA licensed products, to be a good surface disinfectant. And actually, you can make claims along those lines. If there is a headline that the disease control of Atlanta is saying that flu is up 5 times, and we say have something that we believe will support your immune system, and I personally use it as a hand sanitizer, you know, that kind of puffery sells very well.
Bill Gates was talking about 300 million
Jones,
being affected by famine. State the same fact, but qualify it differently.
Infowarsstore.com. You can see advertised all over his website, all over his videos. This is the kind of stuff he was selling. You heard about when I told you that the government is lowering your sex drive so that you won't have any more children? I got something just for you. Super male and super female vitality.
Oh my God! I hope
just
this guy watches.
$52.45 on my website.
I hope some of them watch Fox News and see all the
You hear
pharmaceutical
about
ads.
those food shortages that the government has been inflicting upon you? Don't let them starve you out. I got storable food for you. And the chemicals and the pollutants that they're putting into your water. Get your state-of-the-art water filtration system on my website. Just $59.95.
I got a water filtration system.
Radiation levels are going up. Another government operation. But don't you know what helps with that? Iodine. Iodine mined from 2,000 miles below the Earth crystals.
They sell iodine for camping. Iodine pills to purify water when you go camping.
This one I brought up because it's going to show you the kind of profits Alex Jones was making off of this fear. This is a text message from Timothy Fruget, business manager, to Alex Jones. Timothy Fruget is going to tell you that Alex Jones wanted sales reports every day. Every day. You can see a text message from Alex Jones at 7 a.m. asking his sales manager, how are we doing so far? You look at the second sentence here. The retail for Vaso beet juice, beet essence, will be $39.95 and sale for $19.95. Our cost is $4. That's 1,000% markup. Now I want you to ask yourself, who's going to pay $40 for an eyedropper bottle of beet juice?
Now do a can of Coke.
Yeah, this is going to show you that somebody's been manipulated.
Do a can of Coke that sells for $1.50.
That Alex Jones is the one telling them the truth about everything that they have to fear. And they dig deep for $40 to buy an eyedropper full of beet juice.
Now do a can of Coke.
And so this
or Red Bull. That
is what was
costs even
happening
more.
at Infowars. I want you to look at these numbers. I showed you 2011, but you know we're coming up to December 2012.
He got even more popular.
In those nearly 2 years, this is the audience he was sitting on. Nearly 500 million page views on his website, just Infowars.com. Remember, not Twitter, not Facebook. That's where all the action was. Nearly 500 million on his website.
This is what they said in
76
Texas.
million users, 193 million sessions.
This is about silencing somebody, not about
That's the audience that
actual
was ready to
damages.
tune in for the next outrage on December 14th, 2012.
The thing is, I know that I'm biased.
We're going to talk to you a little
This
bit about
is-
what happened that morning. All of you know. We're not doing it because we want any sympathy. That's not why we're here. But what you need to understand is the truth about what happened that day. Because the truth about what happened is what makes Jones lies about it in mere minutes after it happened so beyond the pale. 9:30 on the morning, December 14th, 2012. Young trouble man comes up, shoots out the window beside the front door, saying to Elementary. The principal, Don Hotstrom, and school psychologist Mary Sherlock confronted in the lobby. They're killed. Erica Lafferty, Don Hotstrom's daughter, is a plaintiff in this case. Bill Sherlock, Mary Sherlock's husband, is a plaintiff in this case. He turned left into a classroom, full of 6-year-olds. Law enforcement raced to the school. Parents, family members raced to the area. Law enforcement from around the state converged upon tiny little new town. We all stopped, the whole state stopped. I'm sure all of you remember where you were. You're gonna hear today from Bill Aldenberg. Bill Aldenberg is a 20-year veteran of the FBI. One of the most accomplished agents in the state of Connecticut.
An
He's part of
FBI
the FBI SWAT team that responded to the school that day.
an FBI is one of the plaintiffs suing for defamation. For
Bill
anybody.
Aldenberg is the plaintiff in this case. But where was Alex Jones? Where was Alex Jones when our entire state, our entire country had been brought to its knees? Alex Jones
Who brought
was
it to
going
its
around for his 11 a.m. start. 11 a.m. Central, noon time here. The school had been secured but an hour or two before. We're talking about within 3 hours. We're talking about when family members were gathering at the firehouse, not even knowing what had happened to their children inside that school, to their loved ones inside that school. And Alex Jones goes on his show. I want you to look at the date. 12/14/12. He's got all his websites up there. And you're gonna see this video. Alex Jones already knew what he was gonna say. He already knew. It's exactly what his audience had been conditioned to believe. It was staged. It's a government operation. He yells into his camera, why does government stage these things? To get our guns. Why can't people get that through their heads? And they said this.
They have hit the ground running in a build-up, and I said, this is the attack. Look, people got to find the clips the last 2 months. I said, they are launching attacks. They're getting ready. I can see them warming up with Obama. They've got a bigger majority in the Congress now, in the Senate. They are going to come after our guns, look for mass shootings. And then magically it happens. They are coming. They are coming. They are coming.
See, reconcile that with the statement that he denied that it happened.
They are coming. See the fear. The fear is striking his audience. That they would do this, that they would stage, the government would stage this.
He didn't say stage there. He said it's gonna happen, and they're gonna be coming
An
for your
audience
guns.
of millions listening.
That's what he said.
Trying to believe it.
In that clip.
And they did believe it. And Alex Jones, in the days ahead, started settling on the lie. The government staged it. People knew about it in advance. The parents were suspect. They were reading from a script, and they were actors. Actors. Faking their grief, faking that their children ever lived. All part of a plot, mind you, to strip his audience of their rights. All part of a plot to ban guns. And if there's one thing that scared his audience, maybe more than anything else, it was the idea of being disarmed by a tyrannical government that was coming to enslave them. And so he went all in on it. He called this video, Connecticut School Massacre Looks Like False Flag, Witnesses Say. You're going to learn that Alex Jones personally titles all of his videos because he wants to design them to get clicks. And you'll see in this video, there's not a single witness who said that. A false flag, you'll see, is a term that means essentially that what they're telling you happened didn't happen. It's fake. It's made up. 3 days later, as the funerals were happening, do you remember that? Funeral. So fast you couldn't even remember the stories of all the children and the educators. And what's Alex Jones doing? He posts a video saying creepy Illuminati message in Batman movie hints at Sandy Hook School. What he's telling his audience is, they dropped a message. These globalists, they're that evil. They have to tell you what they're up to. And the fact that Sandy Hook appeared in a Batman movie is evidence that you should believe means this thing was planned in advance. Now, that sounds ridiculous. And in fact, they're going to come up here and tell you, yeah, we never actually even confirmed Sandy Hook was in the movie.
Yeah.
But this thing spread. This thing gets attention. It's 3 days after the shooting. 3 days after the shooting, a video of Sandy Hook mass media psyops, outtakes, and bloopers. They pieced together footage, made it seem like it was a blooper reel. It's all a blooper reel because it's scripted. It's like a movie. You had outtakes. December 19th. Now we're 5 days after the shooting, and this is where things really go bad. Because Alex Jones now is making it clear what he was suggesting before. The parents themselves are actors. Father of Sandy Hook asks, read the card. Seconds before tear-jerking press conference. Talking about Robbie Parker. Robbie Parker lost his daughter, Emily. The night after the shooting, he came out of his church to give a statement to the press. Let's talk about his daughter. It was important to him that the world know what Emily was like. And Alex Jones called him an actor. He told his millions of people watching, Robbie Parker's an actor. Look at these numbers just for just a second.
Can you play that video? I mean, if I had that as evidence,
How many of these people
in an opening statement, I would play that
came away
exhibit if I had it.
This thing's fake. This thing's staged. Didn't stop. We go into January. Now it's clear.
He's
They're
not playing a
actors.
video. The question is
They're
going to be:
actors.
is there any
It's all
evidence
hoax.
to substantiate what you
January
just said
10th,
to the jury?
Another one. January 10th, Sandy Hook AR-15 hoax. Still no school surveillance footage. And then on January 27th, we're about 6 weeks out from the shooting. Why people think Sandy Hook is a hoax, and he puts Robbie up there. He slows down the video.
So
Calls
far,
it method acting.
find it as objectionable as you
And I want
want.
you to think about
It sounds like he's
what it
describing
means.
opinion.
to have millions and millions and millions of fear-stricken people who believe that you are part of a plot to take away their rights. What it means to have that many people thinking that about you. Because you're going to hear that they were outraged. Why wouldn't they be? These people must be the scum of the earth, pulling a fraud off on the American people to take our rights away, these actors. They need to be exposed. And that's what started happening. You're going to see, days after the shooting, Alex Jones's listeners latched onto this. The harassment started. Funerals needed to have security. And you're going to see that 2 days after he publishes this video, one of the parents who lost his son, Leonard Posner, sent an email to Infowars. I'm very disappointed to see how many people are directing more anger at families that lost their children in Newtown, accusing us of being actors. Haven't we had our share of pain and suffering? All these accusations of government involvement, false flag terror, New World Order. I used to enjoy listening to your shows prior to 12/14/12. Now I feel that your type of show created these hateful people, and they need to be reeled in.
Posner said
Alex
he
Jones.
used to like it.
Never reeled in. You'll see that Infowars top editor actually responded. They knew about the harassment that was happening. But the lie was too valuable to Alex Jones. Take a look at these numbers. From December to January, 38% increase in sessions, 36% increase in users, Page views up 43%. It was working. And as you know, the reason this matters so much is because this audience meant $ Alex Jones. You'll see that over the years, Alex Jones had to keep the lie going. It's valuable. In 2014, this is 2014 now, a year and a half after, he started to enlist people to help him. This guy named Wolfgang Halbig on the show with Alex Jones. Wolfgang Halbig's a guy from Florida. Alex Jones had him on to say that Sandy Hook was a hoax, that it was an illusion pulled off by the Department of Homeland Security. You'll see Wolfgang Halbig coming repeatedly up to Connecticut. Infowars would cover him. Alex Jones would send people to his website and ask them to support him financially. His website was filled with all sorts of hateful stuff harassing the parents. That's the kind of guy that was useful to Alex Jones. Dan Bedandi, an Infowars reporter, former professional wrestler, came up to Newtown with Halbig. They sent him up here with a camera crew. You'll see him harassing people on the street, harassing town officials, saying that Sandy Hook was an inside job and that they were covering it up.
Inside job means it happened. Like these are mutually incompatible
I'm not going to
arguments.
show you all the videos.
Even if he said it's an inside job, it means it happened.
Yes, sure.
Are they going to play the videos of Alex Jones saying that these beautiful children lost their lives? What a tragedy it was that these angels were taken? They're going to play that? So what's going on here? This is absolutely peculiar.
You may continue.
Thank you, Your Honor.
What was that about? No, he did not play the video that said what he said
2014.
when he referenced it. I'm curious as to whether or not that video exists. Or
This is
whether or not
Alex
it's a
Jones
later video.
mocking the parents.
Let's hear this.
He's pretending to cry, just like he said they did. You got all these parents, not just one, but a bunch of parents coming up laughing and doing the fake crying. And he had Wolfgang Halbig on to say that the FBI, actually Infowars said this, and they just wanted Halbig on to talk about it. FBI had said nobody was killed in Sandy Hook. It's a lie. You'll see it. It's a lie. They admit it. Went into 2015. Alex Jones calling it a total hoax. How do you even deal with a total hoax? Simulation with actors. That's 3 years out. 3 years at these families now.
Cynthia, I have no problem with it. They just
Their
the
wife,
sidebars
their
haven't been public the entire
sister,
time. It's not whether or
their
not
mom.
they should or should not be. They were not public in the
This.
Texas trial. They were actually muted for the entire.
2016.
So what's different
This
now?
one, he says, is his final statement on Sandy Hook. It's not. And I want to be real clear here. If Mr. Jones had just stopped in December, a lot of the damage would have been done. Because he was sitting on that audience, and once you send that lie into the world, you ever heard that expression? A lie will make itself halfway around the world before the truth media gets its pants on?
Yeah, I think CNN and MSNBC are familiar with that.
But he kept going.
Are they being sued into oblivion?
This video-
No, their lawsuits are dismissed.
He says, but my heart does go out to the people I see on the news who say they're parents.
That's not what he said,
The
actually.
problem is,
Lawyer.
I've seen soap operas before. And I know when I'm watching a movie, and I know when I'm watching something real. And then he looks into the camera and he goes, let's look into Sandy Hook. And you're gonna hear evidence that that is a call to action. Let's investigate it. Let's look into these parents. Let's expose them for the flaws that they are. Keeps going. 2017, Sandy Hook vampires exposed. Now we're going to present you with dozens of exhibits, but the reality is, of videos and articles, nobody knows how many times they publish this stuff. Even Free Speech Systems, Infowars, they don't know.
No,
They didn't retain the videos.
They didn't send it to us. They didn't confirm the number. That's why they had a judgment by default.
This is Alex Jones in 2021, saying maybe he was right all along. 2021. I want to take you through just one example. Just one example that you can see real clearly about how Alex Jones was cashing in on the misery that we suffered here. Remember the video I told you the FBI says no one killed at Sandy Hook? All right, this is the article here. Now, most of the time, Alex Jones makes his money just by building audience over time. Sometimes something goes viral. Everybody knows what that means. This went viral. It was a lie. September 24th, 2014. You can see he's selling DNA for us right next to it if you want to get that for 33% off. Well, we have data from Infowars for the period January 1st, 2012 through June 16th, 2019. All right, 6.5 years. All the articles they published on Infowars.com during that time. Thousands and thousands and thousands of articles. This article was the second most popular article landing page on the site during that entire time. What that means is people access the site directly to this article. Not the home page, not the videos page, directly to this article. 2.9 million people right on it. And what does that mean? Look at spikes in traffic. You'll see, this is right over the weekend of September 24th. Bang! Unique visitors shoots up. Close to 2 million. Visits shoots up over 2 million. Page views shoots up between 3.5 million and 4 million. What does that mean to the bottom line? September 24th is the day he published the article. Now, this is just one of his sales platforms.
But by the time they play the clips,
this is just one.
by the time they play the clips, they will have forgotten about the emotional impact of this opening statement.
$48,000 on that day. Look at the next day. $232,000 in a day, just on that one platform. Then it drops off a little the next day, except September 26th, $128,000. Then it drops off again. What you're seeing there is the relationship between the lie, the audience, and the money he's raking. Now, $230,000 a day sounds pretty good. Wait until you hear what he was making just recently. So where was all this coming from? He talks about the audience that was growing. In 2014, the year that article went viral, this was his social media audience. 2.2 billion impressions on social media. Billion.
Impressions mean nothing.
2.9 billion. Facebook alone in 2016, 4.1 billion.
I should say this. I don't believe that impressions mean
You're gonna see this text message. This is what I was telling you about. Jones wakes up, just wondering how $sign we are. We ended up about 810,000 yesterday.
Cynthia, by the sounds of it, you're the only one getting more radical here. So enjoy it.
It'll take me a bit to calculate what percentage of that was food, but it's looking like 650 to 700,000 in food sales. We were already over 100,000 today at 6:45 this morning. Crazy.
Well, impressions don't
Now
translate
you can
into
probably remember what was
conversion.
happening in February 2020.
That's my issue with impressions. They make you feel good, but they don't convert into anything. So good. 4 billion
Alex Jones
impressions.
and that fear was kicking in.
Alex Jones and the fear. Now do
But the
CNN.
audience that allowed him to deliver this kind of money into his pocket.
Now do
was built
MSNBC.
years before.
Russia hoax. 4 years of
The audience that he built during his Sandy Hook campaign was paying off. Emoji, emoji, emoji. In the years 2014 and 2016, 9.2 billion impressions on social media, 1.5 billion on YouTube, 2.95 billion on Infowars.com.
Barnes is in the house, people.
He started adding stuff to his platform.
You notice all that, remember all the discovery that was never turned over?
Video.
Where's he getting all
those
this?
little
All
video
the
segments you
articles,
get
all the
every month.
analytics, all the monetary information, all the
Newsworks
text, all the
Set it
details.
up as another
That was
website
always a
like
lie
Infowars.
by this
Infowars
court and a
Juror.
lie by these
Alex Jones
lawyers
went
and a lie
international.
by the media. You're
He
seeing
still
it in
had
live
the Alex
time.
Jones show.
How
He had
did-
another
they
show
have
recorded.
all the evidence. They have more evidence than anyone's
And of
ever been
course, his
forced to
social media
disclose.
presence, which we
So when people
talked
told
about.
you he was defaulted for not producing discovery, the court lied, the media lied, the lawyers lied.
Robert, I'll play devil's advocate for a second. Do we know if this was the stuff that the disclosures that they got late and that they didn't get on time, or that were hidden initially and then they found them?
Either way, they have them. In other words, how do you say that someone did not produce discovery when we're watching in live time a trial of more discovery than you'll see the New York Times ever have to produce in any case? So, I mean, that's what's extraordinary. This is discovery that usually no party has to disclose ever, period, because it's not relevant to the proceeding. They have his private text. They have all his financial information. They have all the Google Analytics. By the way, apparently the judge sanctioned, again, another sanction on Infowars.
They can't
and by the way, Infowars doesn't own Google. Good. I mean, how is Infowars being required to do Google Analytics? That's how nuts this judge is. That's how corrupt this court is in Connecticut. They're issuing bogus orders, and then if you don't participate the way they want in those bogus orders, they sanction you for the judges in the court's own misconduct and malfeasance. But anybody watching this should look at this and tell me what discovery did Alex Jones and Infowars not produce that was so necessary that there was no means to get otherwise, that a default judgment could be warranted.
Well, and even from what I've heard, Robert, it had to do with the profits that he made and not the statements themselves, which were, to the extent it's defamation, they were known, they were public already. So the extent of the profit off the allegedly defamatory statements is secondary.
Completely. As a general rule, it's not even considered relevant. Because, for example, whether you spoke with now, some of the claims here, by the way, are insane. Like they brought claims under the unfair trade laws of Connecticut. How is this an unfair trade claim? What trade was going on here?
Well, but you know what, Robert? I could understand that if that were the basis of the claim. He's using deceitful business practices by promoting misinformation to promote a cure. I could understand that as a basis of a claim, but it's in the context of a defamation claim.
That's what I mean. He's not being sued for any product related. He's being sued for his statements, his speech, and yet somehow that's become a commercial transaction, a commercial trade, which is, to my knowledge, never been done before in the history of the country. And this court knew what it was doing, was completely beyond the pale. This is the same court that presided over the case that led to that ridiculous $70 million being paid by insurance companies for these plaintiffs that are triple dipping, quadruple dipping. By the way, there's a majority of the plaintiffs, my understanding in this case, are not even parents of children. They're like siblings or related parties or children of adults, including, again, an FBI agent who's suing here. And the story they wanted to tell, what you're seeing here is they had no evidence to support their actual story. That's why they couldn't allow a trial by merits. His only claim that Infowars made money on Sandy Hook is a single article, and he extrapolates it in a bunch of directions that don't even make sense. He even points out, he says the article was published on this day, and then it's 2 days later that they have a surge in money, which means the two aren't related. The two aren't correlated. So he has one article that over what he didn't tell people said, look, over this 7-year time period, this one article was a big article. Over a 7-year time period. He doesn't say where it came from, how it translated anything. That's because there's no correlation between Infowars' coverage of Sandy Hook and Infowars making money. Their whole premise was that the two are deeply correlated. Note what he's not talking about. Yeah, there were tons of articles on Sandy Hook. He did not tell them 99% of the articles published by Infowars on Sandy Hook say Sandy Hook happened. So that's why they couldn't allow Alex Jones to have a defense on the merits. A defense on the merits proves that the court's theory is a lie, the lawyer's theory is a lie, the media's theory is a lie. They have to have this fake show trial. And by the way, how does any of this relate to damages? I mean, Alex Jones is not going to be allowed to defend himself on the merits, yet they're allowed to present evidence on the merits when no trial on the merits is happening here.
Robert, did you hear what the judge said in preliminary instructions to the jury? She said, we're not here to discuss guilt. It's been determined. Now it's quantum. Alex Jones did this. He said this. He did not. This was the judge to the jury before opening statements even started. Now, before we fall too far behind, we'll keep going and then we'll pause and catch up.
Exploded. Those are all the social media platforms.
Tell me when you want to pause, Robert.
And every single platform that he was on, driving this message, sending out the word that these folks were frauds and actors, send them to a store. Infowars store, InfowarsLife.com.
Notice the disconnect here, right? He's talking about what Alex Jones does in general. He's not tying in with specificity. That's why he had to cite the one article, because he has nothing. He has no tie between Alex Jones's Sandy Hook and Infowars and Sandy Hook and making money of these platforms. So instead, he just briefly talks about what Alex Jones said in Sandy Hook, which again, he only has a few statements over 9 years. You know, this is a guy who publishes 3+ hours a day himself, another 10+ hours a day live often by other commentators at Infowars, not to mention hundreds of articles published every day. And so you start to multiply that, you realize what a tiny little drop in the bucket Sandy Hook coverage was, which means it couldn't be driving traffic. It couldn't be driving current cash. It couldn't be driving any of that. So what does he do? He talks about this being connected to Sandy Hook in one little example, and then he starts talking about Infowars in general. And he's leading the jury to believe a lie, leading the jury to believe the two are connected when in fact they're not. And that's the switch he's trying to pull here.
You can find his products on Amazon. You can find his products on eBay. So we know what it meant to Alex Jones. You can see hundreds and hundreds and hundreds of millions of dollars. But what did it mean to these
Pause.
things?
I mean, see that statement? He's getting away with saying a statement that's patently false, for which there's no evidence. And as he just said, Sandy Hook meant hundreds of millions of dollars to Alex Jones. No basis for that claim whatsoever. None. In fact, the evidence refutes it. That's why they always needed, and the court knew it, the corrupt court knew it, needed a default judgment because the facts are damning to the plaintiffs, not to Alex Jones. And that's why they're not allowing those facts to be heard by a jury to the public.
Because I mean, like you said it, I said it. He made certain statements, which I think we all agree are stupid and wrong. But repeatedly,
he himself has repeatedly
apologized, recognized that it happened, admitted that it happened, but said, but spun it. Says it happened, and they're coming for your firearms. I mean, this is what in the beginning the lawyer said. Look, this is what he said. He said it was a staged event, so they could come for your firearms, and then they played the clip, and it's not exactly what he said. He said this happened today. They're coming. They're going to use it as an excuse. They're coming for your guns. That's what he said. But again, evidence has not been adduced yet, as the judge sternly warned the jury. This is not evidence. Wait for the evidence on the quantum. Guilt is already determined.
Exactly.
They were defenseless. They woke up one day, they were just living their lives. Getting kids off to school, fixing lunches, going to work, coming home, letting the dog out, just like all of us. And it all stopped. It all stopped, and they were defenseless. They didn't have the platform that Alex Jones had.
Why didn't they have locks on the doors? Just
They didn't know who Alex Jones was.
So he started off talking about Jones. I missed the very, very beginning.
Well, he started off talking about his growth and how he, seized on these opportunities to.
See, like that
market.
To me, that's two things. One, it's a damages trial, so a lot of that shouldn't even have been admissible or arguable. But putting that aside, just as a tactical perspective, emotional narratives drive juries' decisions. That's what the reptile brain and the plaintiff's theories, books by David Ball and on damages and other things are all about. And so you quickly learn that the rational mind, the empirical mind, that this is a myth that they teach in law school, that may be an alluring myth for the purposes of persuading a judge, but has very little persuasive value to a real life jury. When you have such sympathetic plaintiffs, as they have in this case, that suffered a horrifying trauma and tragedy, that's the story you tell right out of the gate. In fact, you tell that. If I were doing the opening statement, that's the story that's much more potent. That's what made this case attractive to plaintiffs' lawyers. Now, this is a very sophisticated, high-profile, very well-off, successful plaintiffs firm in Connecticut. But to be honest, this opening statement, sounds more so far to me like this part here should have been the beginning. This part here, like what we're looking at, exactly.
The chat.
Start with the families. Tell the story through them. Tell the stories through their kids. I mean, I'm not going to go into too much. Well, there's only one more. The last trial left is a small Texas trial, so I can, I don't want anybody to take my ideas, use it against Alex Jones necessarily. But this is from an educational, edifying perspective. When you have a powerful narrative, emotional narrative, start with the emotional heart of your story. Then get to the sort of the villain of the story. But start with the hero. Don't start with the villain, unless your hero is not much of a hero, right? But here, the most powerful, potent part of the story is the sympathies of parents who, and in some cases, kids who lost their parents. But the most sympathetic is the parents who, with their kids. I would have started off with each one of the plaintiffs, what happened to them that day. About their normal routine, how they did things. You know, you're getting your kid ready. You know, all the little things that can happen, whether they're late for breakfast or early for breakfast, or all the things that happen when you're waking the kid up, when you're getting them ready, making sure they're dressed, making sure they're doing what they're supposed to be doing. Hopefully, got their homework, got everything in their book bag. Tell that emotionally powerful story that everybody in that jury can connect to, can relate to, such that it sits with them and it sits with them deep and long. And as you get to the and so that you're ready for them, you're moving with them, and then introduce kind of the shock of the Alex Jones theory. By doing it the way they're doing it, they're making it clear how just overtly political this trial is. They're saying Alex Jones is terrible. You must punish him. Here, by the way, is the excuse. Here's some family members, but it's almost like an afterthought. It's the secondary component.
And the interesting thing is that they started off, I brought up the chat that reminded me, saying Alex Jones believes the globalists are trying to cause starvation, population, like all these things that they want. I don't know. They want people to think it's crazy that anybody thinks these things. They want control over your lives. They want to start famine, this and that. I don't know. Depending on the jury,
it's one of their great mistakes. It was like when you broke down that deposition way back. You listen to the line of the questions. They think anyone who questions 911 belongs either in prison or bankrupt. Mm-hmm. Anyone who questions Oklahoma City belongs either in prison or bankrupt. Anybody who uses the phrase globalist belongs in prison or bankrupt. That those are not only crazy opinions, they're opinions you should be legally punished for holding, punished for espousing, punished for sharing. And the angle they could only tie into everything was to claim Jones became famous and became wealthy because of Sandy Hook, and none of which was true, which they knew early on wasn't true. I think they knew before they filed suit wasn't true. That's why the game they always had to play was, we demand you give us the proof of your guilt. And Alex Jones says, well, I'm not guilty. No such proof exists because I'm not guilty. Judge, he's denied us the proof of his guilt. Default. And that's what's happened over and over again. And you're seeing that here in two different ways. You're seeing it in all the evidence they actually have, more invasive, intrusive evidence than you'll see in any other defamation case. Try to find one where you see this scale of a corporate defendant, business defendant, media defendant. Individual cases can be different, but not a media defendant case. And secondly, you're going to see him throughout stripped of his own ability to defend on the merits themselves because they don't have the compelling case that they want. But the way he is presenting opening statement from a tactical perspective for young lawyers out there, for people who want to tell how to tell good stories and whatnot, this is a poor presentation because this is a political pitch. So unless his jury is already with him politically, this pitch is Alex Jones is a dissident. Punish him because he's a dissident. And by the way, here's the excuse, the afterthought. Here's some families that you're going to write the checks for. But it's almost secondary. It's a side benefit. It's a pretext. It's not the reason for the case as shown by his own structuring of his own opening statement.
All right, let's keep going here.
But he knew who they were. His audience knew who they were. And ask yourselves what it means. When you're lost in grief, trying to find your way through it, trying to take care of the kids that you have left, or the siblings you have left, knowing that there's a whole army set loose by Alex Jones to believe that you're flawed, that you're an actor, that the child you spent so much of your life raising never existed at all, that the grief that's consuming you is all an act. They didn't have enough time with their family members. Like, nobody does, but what they have were memories. And Alex Jones turned those memories into a battleground. So to be ripped apart, defended. And we're going to ask you to consider. I'm going to ask you to consider all that when you're thinking about the type of harm and damage that they suffered. But here's the reality. None of them wanted to bring this lawsuit. They don't want to be here. We trust you to decide what's appropriate here, what justice is here, because you've been through tragedies and hardships in your own life. You know what it means.
Pause. That suggests to me that he picked the jury based on their personal experiences, that they have probably poll tested and focus group jurors in Connecticut to see who would give the highest verdict. And it was likely people who had experienced comparable tragedies or traumas in their life of some sort. Just a little, that reference saying, by the way, this is how he picked you. And what he's trying to do there is bring back that memory. We know, we trust you because, you've all experienced traumas and et cetera. And so what he's trying to do is connect their own personal trauma memory to the plaintiffs. That's a good tactical move, by the way.
And we hope that your verdict is resounding enough to send a message you've been taken in by Alex Jones that they've been lied to. But the reality is that we're never going to put this lie forward. We'll all be gone, and that lie will still be out there. But somewhere out there right now is another family getting their kids ready for school, fixing their lunches, going to work, thinking about picking their kid. And there's going to be a day when that child doesn't come home from school. And we know it, and it's sad, and that's reality. And the question is going to be, where is Alex Jones when that happens? Is he in the studio? Getting ready to pounce? Or will you stop him? That's going to be in your hands.
Pause.
We get all done with all the evidence.
Just like the Texas case. That the whole point of this case is what? To stop Alex Jones from ever being in the
Where's he
studio
going to be?
again.
He's going to be in a studio? No, he should be in a basement, and he should not be allowed to speak ever again. Okay.
It's all about speech. This case is about shutting up and silencing Alex Jones and Infowars and weaponizing the legal system to achieve that objective. Precisely what our First Amendment is supposed to prohibit.
We're going to come back and we're going to ask this. Because that's what justice is in this case. Thank you. Thank you, Your Honor.
Attorney Gaddis?
Thank you, Judge.
Pattis is Jones's attorney. I mean, that
Yes.
was
Norm Pettis is I thought that was an average opening statement, subpar, given the capabilities of a good plaintiff's lawyer. Norm is an old school civil rights lawyer from the left, old school Democratic lefty, but still believes in free speech.
he needs to cut his hair. I mean, who has hair like that?
An old school 1960s
I'm
lefty.
joking. It's just a. That was
Oh, yes. Who does have hair like that?
You know, I know. One of the issues dividing us is guns. Their possession, their control, their use. Their divides are deep in this country right now. Dangerous. Don't let anyone tell you for a moment that this trial is a means of stopping those lives, of discussing gun violence. We're not here to make political statements, to reform the world, to take a stand against extreme speech. This trial is not a cultural moment. It's not even about stopping Alex Jones. I was stunned to hear my adversary's opening statement. The judge told you why we're here. Hearing and damages. Liability has been determined. What can they prove, given what's reasonable? We went 15 minutes into the closing argument and heard a wholesale attack on Alex Jones, and you were asked to do something not related to your mission. Stop.
I like it.
It was
Pause.
25 minutes in before.
Two things there that are really good. Now, Norm has been in a lot of trials. He's an old school street trial lawyer, lefty civil rights, criminal defense lawyer, prominent in Connecticut, represents a lot of people challenging vaccine mandates. And so that gives you an idea for who he is, but that he's very familiar with a courtroom. It's very natural, very confident, very at ease. You see him moving away from the pulpit, but not being locked into a video presentation. So one reason I do like the addition of visuals for opening statements and closing arguments. Visual demonstratives are more memorable by juries, particularly if associated well with associative memory and the language you use. But a common pattern is that lawyers get locked into them. So that's why I don't like writing out, going with a written argument or statement, because you end up locked into reading it from the speech and it loses its emotive efficacy. The other problem is doing things that guard you, as the body language people have explained many times, lead people to trust you less. You can watch the body language, the behavior panel about the debates. And they mentioned one good thing with the debates is when someone steps away from the podium and makes their whole body vulnerable. And by making their whole body vulnerable, they become more trustworthy to the audience. So this is something that's universally applicable to anybody in any public presentation context. What Norm just did there that was very good is, you notice he's not locked into a video presentation. He's not locked into a podium. He's making himself fully accessible repeatedly to increase the trust and confidence level. Also, to be honest with you, the ponytail works. Ponytail identifies him as, oh, this guy's an old school lefty. You're in Connecticut. You got a lot of liberal Democratic jurors. The only person who's going to be accessible to them or emotively relatable to them for Alex Jones is going to be an old school lefty that reminds them of someone they used to know and like, those are the hippies.
He looks like a Grateful Dead fan, potentially.
Absolutely.
Raining in his hair for his day at court.
The kids these days follow Fish in the same manner. The band Fish, for those who may not know it. But the second thing here that I really like in both opening statements and closing arguments, when you get to reply to the other side, you don't have to go first. Use what they say, take their weakest point and hammer it. And it's all the Sun Tzu principles. To defeat what is strong, attack what is weak. So you find the weakest point of that statement and you jump on it. And he realizes the only way this verdict gets out of hand is if the jury thinks they're on a moral crusade to weaponize the legal system to prohibit Alex Jones from ever having speech or press rights of freedom and liberty ever again. But he also realizes that's a vulnerability. That's a vulnerability because it's like, hold on a second. So we're not actually here to assess what injury somebody suffered, even though the judge just said that's what the trial is actually about. That I'm being misused as a juror to do something that really violates something that I should find offensive, someone's free speech and press rights. So he took what was meant to be the strong point of a too political opening statement by the plaintiff's lawyer, and he used it against him and flipped it because he realized the weak link of their case, the strength of their case is the emotional sorrow of the plaintiffs, much of which has nothing to do with Alex Jones, of course, but they're hoping to draw the jury's sympathy to just write a check. He realized that the weakness is how political this case is. So him going and saying, I'm shocked to hear they want you to do this. They want you to do something that the judge just told you you're not supposed to be doing. You know you're not supposed to be doing. This isn't about shutting up and silencing Alex Jones. Why are they talking about that? Making them refocus their damages award accordingly. So that's also a very good tactic that Norm used right away.
For the word 35 minutes and before the word damages even arose. And then we'll trust you to give them damages, and their damages is stopping Alex Jones. Let me be bold here to decide for you, or to ask you to decide for the millions of fools, the millions of deplorables, the millions of MAGA Republicans, what people can and can't watch in this country, because they transformed the hearing and damages. They transformed money into a political weapon in this trial. And we're going to ask you to disarm now.
Oh, Pop.
We don't want you to do anything here, but follow the law.
Great. One, he keeps hammering on it really well, but great use of the word disarm. Yeah, perfect time, the way to integrate that. And so it's just a good verbal turn of phrase. But he realized he's onto something. Hammer, hammer, hammer. Also, repetition is a gift. People think repetition is bad. It's not. There's a reason people repeat things. They become much more memorable. They stay in the mind. They stay in the brain. I've occasionally made the mistake in trials of thinking, geez, I'm probably saying this too many times. I've had judges scold me, say that's too many times. And when I didn't keep repeating and double down on repeating, it backfired on me. I'd have jurors come up to me later and say, I really wish I knew this point. I was like, oh, that's the point the judge told me to quit repeating. So this is a much, you're seeing, like, people have wondered why I've been hypercritical in their minds of some of these other cases we've watched. It's because this is how a good statement works by a lawyer. And to date, we honestly have not seen a good one until today with Norm.
As the court instructs you on. That is your obligation. No more, no less. You'll hear nothing from the judge about stopping Alex Jones. Yep. You all remember, if you're old enough, where you were on December 14th, 2012. Where maybe I was in a courtroom. Maybe I heard that and I thought, my God, what's become of our world? 20 children, 6 adults slaughtered by Adam Lanza. These are the names of the children killed. Jessica Redbus, you should pause and remember each of them. Olivia Engel, Avio Richard, Jesse Lewis, Grace Audrey McDonald, Noah Posner, Anna Marquez Green, Emily Parker, Charlotte Bacon, Catherine Hubbard, Josephine Gay, Daniel Barton, James Macchioli, Carolyn Pavetti, Allison Wyatt, Dylan Hockley, Madison Sue, Chase Kowalski, Jack Pinzo,
Pause real quick.
Benjamin Wheeler.
Just want to answer this chat. The reality is the human brain. I recommend to everybody David Mamet's very short book, 3 Uses of the Knife, talking about a blues song. And the point is the human brain cannot process facts in isolation, that it's just not capable of doing so. We have a neurological need right into the architecture of our brain to interpret, construct, and contextualize all factual information in the framework of a story. We cannot understand facts outside the framework of a story. So I get the idealistic approach that we could have empirically computer AI-driven processes in our human brains that can neuter the relevance and pertinence of narrative to factual presentation. But the reality is nobody's brain works that way.
Those are 20 young lives wiped out for no reason at all on December 14th, 2012. Each had parents and families who loved them. Each victim is missed, loved, and mourned, sure, to this very day. But that's not why we're here. The adults killed that day: Victoria Soto, age 27, Lauren Russo, age 30, Dawn Hawksford, 47, Mary Sherlock, 56, Rachel Davino, 29, Anne Marie Murphy, 52. Those are the 6 adults senselessly killed at Sandy Hook that day. We're not here for that. Each of them had families. Each of them, I'm sure, are mourning to this very day. Each of them. The plaintiffs in this case, not all the families and members of those victims chose to be here today. 14 family members representing children and adults, 4 children and 3 adults chose to be here. An FBI agent chose to be here. A parent or parents of Emily Parker are here. A parent or parents of Daniel Barton are here. A parent or parents of Dylan Hockley are here. A parent or parents of Benjamin Wheeler are here. Members of Victoria Soto's family is here. A member of Dawn Hawksford's family is here. A member of Mary Sherlock's family is here. And of course, a retired FBI agent is here. 2 other children's parents brought seats elsewhere on another day.
Nice. You notice he's now done, I think, 3 times. And a retired FBI agent is here. And a retired FBI agent is here. And a retired FBI agent is here. Planting their head, a great way to get a jury to go in your direction is to get the jury to believe that they have come up with the conclusion that you want them to get to, and not to give them the conclusion. If you give them the conclusion, they will be skeptical. They will think, okay, this person's attempting to get me to think something. By contrast, if they think they uncovered it themselves, if they think they discovered it themselves, if they come to that conclusion before you're there. I mean, I know I'm in a good jury when I do focus groups, when I know the argument's working well, when the person's like, oh, I already know what's happening. I'm going to be able to tell you what happened before you know what happened. and what he's doing there is planting something in their head, letting them go to their own conclusion as to why is there a retired FBI agent here without making that explicit right out of the gate.
And by the way, we're on break. When we're done with this, then we're going to move it over exclusive to Rumble. So we'll finish with the opening.
All assert that Alex Jones caused them grave harm. Their lawyers are here to prove that. Grave harm doesn't mean stopping Alex Jones. Our suggestion is you stop Alex Jones and do a graver harm to the public. Your job is to decide if Mr. Jones is responsible for all they are claiming. In other words, we claim that their claims are exaggerated.
You wanted to say something there, Robert?
Oh, I do like Inception.
And if they can prove to you that he's caused them all the harm they claim, then give them a sum that compensates for them for that. They've suggested your job is to punish Alex Jones, and you won't hear that from the judge. They hate him because he says outrageous things, and the haters want his silence. Each of you has chosen to be here today to compensate them for their grief, and you're being asked to make an example of Alex. Money is their weapon of choice. Award enough, and you might summon, or you might silence Alex Jones. He was mocked. They're coming, they're coming, they're coming. The plaintiffs and their counsel hope they're here, and it's you. That with money, you'll do what no one else, you'll do what most of us do at home when we hear something we don't like. We turn on the TV set. Listen carefully what will be said about money in this case. Will they themselves ask for a sum that reasonably, the parents, the plaintiffs, will they ask for a sum, or are they going to let their lawyers pick the sum? This isn't a casino. You're not clerks at a grocery store selling quick pick tickets. They have the burden of proof, and they have to prove it.
Pause.
Your job is to do justice.
You see what he did right there? In other words, he could have said, they think they won the lottery and they want you to give them the lottery. Instead, he makes it more subtle, more indirect. You're not a clerk. You're not at a grocery store selling quick pick tickets, which, by the way, if those people don't know, that's a lottery tickets. So, in other words, he's saying he's doing two things here. He's saying, if your damages go too high, you're going to take the bait of punishing Alex Jones, which you know you're not supposed to do. The judge has told you that's not what you're here for. You know that's what you're not. And that's really unconstitutional, and as he called it, a graver injustice to do. So now he's putting in their head, okay, I as a juror, I need to make sure this damages award doesn't lead to punishment of Alex Jones, which is going to lead me to bring it down. And then the second part of it is I need to not treat this like it's a lottery ticket or it's a casino and I can just get whatever gambling, whatever winnings I want or they want. It's got to actually relate to pain caused by Alex Jones. So what's the real empirical anchor for the amount that they're going to ask for? So he's putting those two burdens on them by making the higher, because every case is a white hat, black hat case. And he's saying the black hat is if you make the mistake of punishing Alex Jones in order to suppress speech you don't like. That's the black hat. And the white hat is only reasonable compensation for actual injury actually caused by Alex Jones, empirically anchored by real evidence.
You'll learn in this trial the plaintiffs did not file suit here until 2018, even though, as their counsel said, all the damage was done in 2016. Almost 6 years after the shooting, 6 years after Alex Jones told millions of listeners the shooting was a hoax, no one died, parents were crisis actors. Alex is liable for this. The judge has told you that, and we respect this court's ruling.
I wouldn't.
In the prior proceeding, the court determined Alex was liable. If you don't know why, you must not speculate about why. It is not an issue for you. You're here to determine whether the parents, family members, and an FBI agent are entitled to more than nominal damages. Listen carefully to the evidence. At the end of the case, we'll tell you that they are not, and we'll tell you why the evidence supports that verdict.
Yeah, I'll get back to this. I agree with you on that.
Alex will testify, and he'll tell you that by the time this lawsuit took place, he'd long since talking about the suit. He was broadcasting 4 hours a day, about 10,000 hours since then, 6 days a week. The plaintiffs will show you the most hurtful videos and articles they could find after years of litigation. You'll hear from employees of Alex's show, Infowars. No one, not the plaintiffs, not the Alex Jones, no one knows how many videos he produced. In part, that's because there was a culture war going on in 2018. He got deplatformed, Alex will tell you.
Objection, Your Honor.
The archive.
Objection, Your Honor.
Sustained.
Well,
The
what's the
So
basis?
pause.
Yeah, what's the basis?
So the
of
judge
objection?
is not allowing him to explain that YouTube deplatformed him.
Yeah, so that he
and the
could not
reason-
comply.
And the problem with the judge, you see the judge's quick ruling. You know, this is her prejudice and her bias wearing it on her sleeve. Immediately not allowing it, not even allowing a sidebar argument to be heard. Normally, that's the protocol. He doesn't even state the grounds for the objection. So you know you see the judicial bias right in action right away. This is not following regular protocol. This is not following regular procedure. This is not following regular custom and practice. This is not in conformity with the rules of evidence or the rules of argument. Rules of evidence somewhat apply here as well. And the reason why she does, and in my view, the plaintiffs opened the door on this because they specifically said that they talked about the Infowars not knowing how many videos they produced on this. So in my view, they're entitled, implying it was so many that they couldn't even keep count of them, knowing, by the way, that that's a lie. Plaintiff's lawyer allowed to mislead the jury by this corrupt court. So instead, you see Pattis try to answer that and it being precluded and excluded. Now, let's say you're Pattis and you know there's a chance, given the judge's bias in the case, that will rule that way. You're doing two things here. One is you're planting the thought into the jury's mind. And so when things get cut off, you let the jury, why is it I'm not allowed to hear certain things? Why is it I'm not allowed to that there's something about this case that seems wrong in the jury's mind. So you're letting that seed be planted. Secondly, you're establishing, and the best way to do this is if this happens to you live, I've done this on occasion, but different lawyers differ in strategy. I will often go up and make a proffer. Say, here's the rest of the statement I would make. I believe it's permissible. Here's why. Just to establish the appellate record. Some lawyers do it after the opening statement. They request reopening for the purposes of clarifying that. There's ways you can do it. It depends on the lawyer's personal style, which is the way to do so. But that's why the judge is trying to preclude the jury from knowing. The reason they don't know the scale of their videos is two reasons. One, they didn't keep digitized indexes of a sophisticated form. That's not Infowars, a talk show. Most media networks don't. They don't have that kind of record. Only your big corporate media networks do. And then secondly, what were they using as their main mechanism of storing videos and broadcasting during this time period was almost all on YouTube. And so what he was about to explain was that YouTube, at the request of the plaintiffs, due to the nature of the case, YouTube not only deleted his channel, but they wouldn't give him any of his archive. And he no longer had access to his own archive. It was gone forever. And that's why they can't search it, because YouTube even transcribes different things. They couldn't get access to that. That's the reason, not because there were so many videos and stories done on Sandy Hook, which is a big fat lie. It's because they, in fact, and by the way, in a libel case, how can you sue over statements you didn't hear and you don't even know exist? Someone should ask themselves that question. But this is why the court, it doesn't want the jury to know the real reason, because it would also expose the judge, right? This judge has issued a default judgment, misleading the world into believing Alex Jones didn't participate in discovery in such a meaningful manner that her only remedy was the extreme death penalty sanction of stripping him of a jury trial, right, under the Connecticut Constitution and United States Constitution. And she doesn't want the world to know, oh, by the way, the reason why it wasn't easy to find and access videos and information is because of YouTube's deplatforming that happened because of what the plaintiff's lawyers were demanding.
He will tell you that storage of videos was removed. YouTube, he didn't have access to his own archives. Why these parents? Why not the children of...
There we go.
Now that's pure natural skill as a trial lawyer right there.
He got the statement out that the objection related to.
So he let the lawyer object. He let the judge sustain it. He acted like, okay. And by the way, here's the rest.
For the others who never filed suit in Connecticut or Texas, you will learn that each of the parents and family members here transformed their grief and rage over the death of a loved one into a powerful and effective motive for opposing gun violence and promoting school safety. And who can blame them? Who can blame them? They're members of interest groups, they hold vigils, they testify before Congress and state lawmakers, they've become partisans. They've walked into a divisive debate about guns and the Second Amendment and the extent to which the state should be more aggressive in making us safe from madmen. Do they overstate the harm that Alex caused them because they want to silence him for political reasons? Because he disagrees with their point of view? I would suggest to you that is the case, and we'll argue that.
Is there an objection?
Sustained.
Maybe a sidebar, please.
Oh, okay, quickly, Robert. We've got to hear that. Well, we're behind anyhow, but what were you going to say?
Yeah. So that was a really well done aspect. So how do you take a case that, according to the plaintiffs, it's these nice, quiet, private parents who are being harassed by a so-called army, where Alex Jones is the general, for his own personal profit. That's the plaintiff's story. What he has done is reframe this to what it actually is. Say these are people who, for understandable reasons, became political partisans. They became advocates for legislative reform about issues related to guns, about issues related to schools, about issues related to public safety. And in the process, they entered a politically divisive culture war. And that's where Alex Jones' step comes into the equation, not in the context of them being private parents grieving, but them being public partisans advocating. And he's on the opposite side. And the real reason for this case is because of their partisan disagreement with him, not because of personal harm caused by them as private parents. Now, the objection, I'm sure, is they don't want. Now, I don't know how that isn't pertinent. This is about damages. Did they actually suffer emotional distress from Alex Jones? And what would compensate for that? Clearly, their motivation, clearly their other approach to him, their belief. I mean, all these things would be relevant. So the fact that, and notice how quickly the judge is ready to say, sustain, sustain. The plaintiff's lawyers could blow a leaf across this lazy, corrupt judge's desk and she'd rush to sign it. That's how pitiful and disgraceful this court is.
Well, let's hear the sidebar, because we're going to hear an interesting sidebar now. They've been doing
Just
this.
1 moment, please.
The sidebar's live, Robert, but the jury's not supposed to hear the sidebar, right?
Correct.
Okay.
So we're not either, right?
He's objecting. There's something about no bearing on damages.
Yes, it does have bearing on
I think motive and bias, I'm sorry, I apologize.
Well,
I think motive and interest in the outcome are never collateral. And I think that we can argue that they're exaggerating their damages claims for ulterior motives. I think that's. Okay.
Okay, he made a good point.
He did. He made the exact point I made.
Yeah, she's going to sustain the objection.
Look at that fake smile, the judge. I mean, doesn't she come across as a mean, vindictive?
Her opening instructions to the jury irritated everybody in the chat.
Our contention, to be clear, is that the damage claims here are exaggerated because of the idiosyncratic motives of the plaintiffs, transforming their griefs into political weapons. You'll have to decide whether that's true. But here's what.
Great phrase. Transforming their grief into political weapons. That is exactly what the case is about. But that's a great cap depiction of what that's just a very good phraseology. It's a memorable phraseology. It takes, how do you take grief and make sure it doesn't equal a big monetary amount when that grief isn't the real reason we're here? You make it, and that Alex Jones is not the source of that grief. You do exactly what he just did. You hear the word grief and you think political weapon, and all of a sudden you go from wanting to go up in damages to wanting to go down.
As you learned in 2016, Alex Jones became a household name again when a presidential candidate used him to berate her opponent and talked about Sandy Hook, Hillary Clinton. She never got sued. Hell,
Objection, Your Honor.
Sustained,
Can we stop this, please?
sustained. Move on, Attorney Pattis, please.
How many times did you notice how many times I objected?
Pause.
Telling you
So what's the one person this corrupt hack judge won't allow to be named in this proceeding? The one person who put Alex Jones and Sandy Hook on public blast, Hillary Rodham Clinton. If this doesn't expose what a corrupt court this is, nothing else better does.
I'll tell you, I like the fact that he doesn't even look back at the judge before moving on. Is head back to her, looking at the jury. Let's hear what he says.
letting them tell their story.
All right, Attorney Pattis, that is improper, and either
Sanctions.
finish your
Sanctions.
opening or be seated.
In 2017, Matt Alex was interviewed by
There's a word for this
Kelly on
judge,
NBC.
and it rhymes with rich.
It'd be a hit piece.
I
He
just
sat
love
for the interview.
Totally
Wasn't
ignoring
it?
her. He's just back to the judge.
Megan Kelly didn't get sued. Alex got sued.
Objection,
Sustained.
Your Honor.
Attorney Pattis, one more time, and
Sanctions.
I will
Sanction.
ask you to be seated.
People wrote these folks hate mail. You'll read. People stalked them. People
Is he
threatened
going to do
them.
it? Is he going to let
People
her
appeared at some of their
make him
homes.
sit?
Each slight, some of them will tell you, was as though a scab had been torn from a wound that will never really heal. They blame Alex for all of it, all of it. You've heard some of the things that Alex uses to spread fear. When Alex testifies, he'll tell you, he had on his show a man named James Tracy, he's a co-conspirator with Alex, as they'll say, a professor who questioned it. James Fetcher, who wrote a book, No One Died at Sandy Hook, another co-conspirator that Alex is responsible for. You already heard about Wolfgang Holbein, another co-conspirator that Alex is responsible for. Stephen Piesnik, a man with shade who claimed ties to the intelligence community, another conspirator that Alex is responsible for. And all the unnamed and unknown persons that they will tell you about but won't be able to identify. At the center of this web of lies and deceits is Alex Jones, the bag man for conspiracy theory, poster child for the battle for the truth. Meanwhile, Alex will tell you the internet remains awash with folks who thinks the CIA killed Kennedy, 9/11 was an inside job, and COVID was a pretext for government control of our lives. At the end of the case, you'll be asked to evaluate the evidence and ask what exactly they proved. That it hurts to lose a loved one. The world is filled with unhinged people. We're becoming a failed state. Alex is bold, loud, brazen, often offensive, and a liar. You can score on our side how many times they use the word lie. It's 8 so far. Liar, liar, pants on fire. They can't shout enough. We could respond by saying, and I ask you to consider this each time you hear the words, 6 and stones may break my bones, but words will never hurt you. When did political debate become toxic?
I like this guy.
What will they prove and how? You will see videos of Alex ranting, raising questions, poking holes at things we all accept. You'll hear and see news stories. You'll hear and have heard about his reach. He spreads fear. Does Alex go out and create his viewers, or is he the canary in the coal mine, responding to something you feel in the world, that something's not right? Do they get to turn him off for you? Is this about stopping Alex Jones, or is this about their proving their damages? You'll be asked to conclude that because he caused the anonymous and almost always unnamed person to harass the plaintiffs, they need millions and millions, maybe tens of millions of dollars. Seriously? Who's Alex Jones? He's a mid-40s Dennis the Menace. Remember the cartoon character? The kid who was always in trouble doing more things than he could? That was Alex. Now he's in his mid-40s. He's got a television station. Some people find him entertaining. Some people find him informative. Most of us just ignore him. He
Most
moved
of
from
us
Dallas,
just
Texas,
ignore him.
to Austin, Texas, as a young man and became a cable TV phenom. Soon he was broadcast coast to coast, questioning what we all know to be true about the government's killing of 80 folks at the Branch Davidian compound in Waco in 1993. What happened at Ruby Ridge when government agents killed Randy Weaver's wife and child in 1992. He raised questions. Did Timothy McVeigh act alone, or did he even cause the devastating bombing at the Murrah Building in 1995 in Oklahoma City? He killed many children, wiping out a daycare center. He called the bombing of the World Trade Center before Osama bin Laden bombed in 2001. And he'll say, what was the government not seeing that I could see from a small radio studio in Austin? And he'll tell you, if he's permitted to, about the Trilateral Commission, about world government, about Chinese plans to take over the world.
How do I do it? There we go.
Very good line there. You see how he got that in? He said he'll tell you if he's permitted to. In other words, now he's incorporating, this is a political case. They told you it's political. They told you their definition of justice is to punish Alex Jones's speech. This isn't about compensation. This isn't about families. This isn't about grief. This is about political weaponization of this case for legal to do something the Constitution prohibits, and is now integrating the court's sustained objections into part of this political case, saying there's things he wants to tell you if he's permitted to. And he timed this after 3 different times she scolded him and cut him off, saying, see, even the court doesn't want you to know what the whole truth is. And if the truth will set them free, why is the court so scared of even a liberal Democratic Connecticut jury hearing the truth about what Sandy Hook and Alex Jones said and did and the whole story of it? And he did a great job. And notice how he, right after he did, if you're permitted to, he did it quickly and then moved out, didn't drag it on, just quick, boom, in and out. And then he transitioned to some of the hottest topics. Here he's doing a good job of what, honestly, the lawyer, I wish he would have done in the Austin case. Now, maybe, that judge might have locked him up for forever, so who knows. But here he ties in these other issues, ties in Waco, ties in Ruby Ridge, ties in Oklahoma City, ties in 9/11. And then he transitioned into that, and this is the week, Sunday was just 9/11. And then in terms of the anniversary date, and then ties in if he's permitted to, and what does he go to? The Trilateral Commission. These big things that a lot of what the plaintiffs probably don't know and understand because they live in this tiny little political bubble is an ordinary person, an ordinary juror believes at least one major conspiracy theory. The average person in America believes at least one. These elites think that nobody could credibly believe any of these. They're the idiots. They believe in some of the dumbest conspiracy theories known to man. So that's smart that's relatable, right? You want the jury to be able to relate. How do they relate to this Austin, Texas radio talk show guy, this over-the-top personality? He's making him relatable in 2 ways. One, he's kind of the out-of-control kid, always doing some crazy stuff and acting up, and everybody kind of knows somebody like that. Maybe they were that way themselves at one point. So that makes him relatable, and it puts him in a whole different context. And that's why he said, look, some people love him. Some people listen to him. Maybe he's really the canary in the coal mine on some stuff, by the way. But, yeah, most of us ignore him, right? So he's saying, is this someone you would take seriously? Is this someone you would get upset or offended by their statements? Really? And maybe we really want that speech because it does present, maybe I should look into that and double check. And while doing the kid story and then incorporating the politicization of the case. So very good job personalizing Jones in an accessible, relatable way. And making the broader topic protecting speech because it can be the canary in the coal mine, and this whole case being a political hit job.
Tell you about globalists. He'll tell you that he thinks there are big money, big tech people seeking to exert control over how we live our daily lives. Long before you were reading news stories about artificial intelligence and big tech, Alex was screaming about it. He's an angry populist warning you about the loss of significance in your own life.
Great definition. That's
Ever
exactly
heard
what I
of
was
Davos or the World Economic Forum? He'll tell you about that. Or Klaus Schwab.
See, very nice.
He's just written
touching
another
on
book.
something he knows.
The Great Reset, the War for the World. Bestseller on Amazon.
Objection, Your Honor.
He'll tell you this.
Overruled.
The answer to 1984, Orwell's classic, he tells you is in 1776. It's a serious message. It's not a lie. We live in deeply divided times, and plenty of people think 1776 is the answer to the 1984 we are becoming. He's also the guy who worries that the chemicals in our water might be turning frogs gay, that weather balloons are secret government weapons, that trails from airplanes are seeded with toxins that are destroying and controlling us.
Here's a good thing, because here he's saying there's one of two possibilities with you as a juror. One, you either think these things are totally wacky, crazy, almost comedically crazy, in which case would you be bothered and offended and upset and emotionally distraught by what Alex Jones has to say? Or you actually believe one of the things you're talking about, and you're thinking, that's not so crazy. That's not so nuts. I want someone to be able to voice that opinion. That's why it's win-win, no matter which side of that aisle you fall on. And the number of people who believe one of the things he's talking about right here, and he's like covering his mouth, which is like, geez, I'm not even supposed to talk about this. You know, that's the subtle hint. It's because some of those jurors are thinking, well, I know that they're turning the frogs gay. I know they're poisoning the water. I know there's something with the water.
I know.
Right? Just one or not all of them by any stretch, but chances are, I've seen the public opinion polling data on this. I've studied this for a long time, independent of Alex Jones. People believe at least one thing that the mainstream media thinks is crazy. They believe at least one conspiracy theory that mainstream media thinks is crazy, and they're personally attached to them. And that makes them think, okay, so Jones is a guy that comes from this very distinct perspective. And either I think it's crazy such that I don't pay attention to anything he says and wouldn't be emotionally distraught because he said it, or two, I think I really believe some of those things and I want other people to be able to listen and hear to those ideas. That's how it's win-win.
That Hillary abuses children, that pedophiles run the government, and that people actually eat babies to remain forever young. Which of these messages do we take serious enough to regard him as a threat we should shut off? And at what point do we regard him as the crank on the village green, a person we can walk away from if we choose to? He's an ordinary populist who fears the rights of ordinary Americans will be swallowed whole by big business global billionaires. He thinks we are on the cusp of slavery, I tell you. But to be enslaved, we must first disarm the people. The Second Amendment must be dismantled. You saw yourself the controversy over the U.S. Supreme Court's decision just the other day. He fears the government will seize any pretext to disarm us. And so on 12/14/2012, he saw a plot, and he did the unthinkable to a grieving parent. He questioned the pain of confinement. And for this, he must be silenced. That's what this case comes down to. We silence and historically have silenced the unusual, seer, madmen who tell us things too uncomfortable to bear. If you try to silence Alex Jones in this case, you'll be asking big oil to silence Greta Thunberg and her concerns about climate change. Don't fall for the political narrative.
Object to the continuing suggestion that.
Sustained.
Thank you.
Continue, Attorney Pattis.
Alex will testify.
The continued suggestion that their own opening statement is somehow what the case is about. He made the opening statement. He made the opening statement that said justice equals taking Alex Jones off the air, not letting him go back into that studio ever again. He chose to make that, and now he realizes how damning and damaging it is, and he wants it not to be allowed for the defense to actually do it. A defense, which is that's a microcosm of this entire case, stripping and silencing and gagging Alex Jones in the courtroom so that they can permanently gag him outside it.
He's apologized. He will tell you that he's grown weary of the expense and time this litigation has consumed. You'll see a video of him erupting on air, so frustrated he's beside himself. I killed the children. I killed them. I went into the school. Bam, 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 bam. Shot each one of them. Yep, that's right. When I go out on the street, people forget Adam Lanza was the killer. They think it's me. It made a scapegoat of Alex Jones, a whipping boy. We will ask you for justice here and put an end to our 10-year preoccupation with Sandy Hook. No one on my side of the aisle will minimize for a moment what these people lost. It is unthinkable. But what you stand to lose with a verdict that silences Alex Jones is unthinkable as well. It's a marketplace deprived of a voice you should have the choice to hear. You will make the world a better place by returning a modest verdict here. A verdict that acknowledges the distress the parents felt, but a verdict that also states an inconvenient truth. All that these parents have suffered does not transform them into oracles that let them determine what you should and should not be able to hear, do, and say. Exactly. Money is their weapon.
Exactly. That statement is what these cases are about. That suffering this terrible trauma or tragedy doesn't give you the right to censor and suppress speech you don't like. That one doesn't equal the other. If someone caused you injury from making false statements about you, that's recoverable. What's not is the right to use their speech because you don't like it, to censor it and suppress it forever. And that was he's done this throughout. Don't let grief become a political weapon. Don't let trauma become the basis of suppressing and censoring independent speech. Don't let this be this case about reasonable damages proportionate to actual harm inflicted by Alex Jones, not suppressing and punishing free speech and press in America.
Follow the law.
Yes. Disarm them. First they came for Alex Jones. Who's next?
Great line. Great way to conclude.
As you will recall from my preliminary instructions, opening statements are not proof. They're not evidence. They are simply statements.
Well, it's obvious why she's reminding them.
Yep.
Also,
Ignore what they
saw that
ignore the
Attorney
defense.
Maddie
Ignore the defense.
objected during the opening statement. A lawyer has the right and sometimes the obligation to object, and you should not hold it against Attorney Maddie or Attorney Pattis.
See how these mean judges, they can't even hide their meanness and their... See, this is why a lot of judges, in the federal system especially, never want there to be cameras in the courtroom. Because when ordinary people, like a lot of people thought, oh, Barnes likes Alex Jones, he once represented him, he's, exaggerating about these judges. And then people see them and they send me messages and say, you understated it. These judges are some of the worst human beings I've seen in my life. I wouldn't want this judge to judge anything, not my landlord-tenant dispute, nothing.
She's saying, don't hold the objections against him if it's him or Pattis, except Pattis didn't object. So what she's basically doing here is she's just playing defense for the plaintiff's attorneys because he's the only one who objected. And that's don't hold it against him. Sometimes he has the obligation to do it. He's actually doing his job well. And if Pattis didn't object, he's not doing his job well.
And you're seeing a gender dynamic present. These sort of maternalistic, the rising statism of political beliefs comes overwhelmingly from women with college and post-college degrees. But it's not just that group. If you study it more psychologically, you find, by the way, higher levels of mental disorder. This is just the studies. So take it up with the studies, folks. But that liberal women report higher levels of mental health problems than pretty much anybody. But in the political spectrum as a demographic. But what you're seeing is they can't even hide it in their facial posture. The hostility, the meanness, the vindictiveness, the power madness. They are physically what you imagine them to be. And this is why a lot of them don't want the world to see them on full display.
He objects if the lawyer makes objections, regardless of whether the court sustains or overrules the objection. So we are going to take a 10-minute recess. I'm going to excuse the jury first, Mr. Ferraro, and I am going to stay on the record to deal with some housekeeping issues. All right?
Is that going to be
during this recess? Remember, you are to abide by the rules of juror conduct that I went through in excruciating detail. Okay?
No, it was excruciating.
So we will see you shortly, and I will remain on the record.
Robert, I think we're gonna bring it over to Rumble
in
2 minutes. It's been 2.5 hours, not half an hour.
Yeah.
People, here's the link. Rumble link. I think she's going to chew out the judge, Pattis. She's going to chew out the lawyer.
There may be water down the hall too.
She's going to chew out the lawyer for having not listened to her objections, but not in front of the jury because she's objective and fair. Let's see what happens here. Mr. Pattis.
Please be seated. So 10-minute break gives us 25 minutes. I plan to start and go that 25 minutes before the lunch recess. I'm going to maximize each day the best that we can. I do want to state on the record that in the overflow courtroom, it came to my attention that someone was
live streaming
in violation of my court order, filming and photographing the opening statements and apparently posted it on Twitter. I did confiscate the device. I had the individual removed from the courthouse. I'm not playing here. If anybody in this courtroom or the overflow courtroom is using their device in an unauthorized manner, I will confiscate it and you will be removed from the courthouse. So only the individuals who are have been previously authorized may do so. Mr. Farrar, I think the one juror in the front row in the black sweater, I didn't see her juror sticker on her. I don't know if it fell off or if it was hidden, but can we please make sure that it gets on her? Okay?
20 seconds. We're going to rumble, people.
Your Honor, we have a request for a curative instruction. What I expect when Alex Jones comes up here, he's going to violate the court's orders. I expect that. I do not expect Attorney Pattis in his opening to unwind the default
sanctions
by repeatedly stating and suggesting that Alex Jones was just questioning. Are we gonna silence the crazy person in the town square for just? He was doing it by referring to the other events that Alex Jones has questioned. The jury is going to be instructed that Alex Jones intended these statements, knowing that they were false, and so we need a curative instruction at the outset. Because what Attorney Pattis has done has injected not only politics, but he's injected this idea that Alex Jones was merely questioning when the jury is going to be instructed in the courts to determine that he intentionally inflicted emotional distress, that he intentionally lied, that he acted with malice.
I hadn't intended to go as far as I did until I heard the opening statement that my adversaries gave. And this is not an issue. I could have objected at the first sentence. This has nothing to do with stopping Alex Jones. This is a compensatory damage claim. And they went 15 minutes. Stopping Alex Jones is not an element of their damages. They went 15 minutes before they even turned to anything related to Mr. Jones, 35 minutes before they mentioned the family. And then they gave a passing reference to damages. Alex Jones must be stopped, they said. It is our contention that Mr. Jones, that the plaintiffs in this case exaggerate the harm that he caused to him, or that he caused them, and they exaggerate it for political reasons. And so if they had not come in and said, stop Alex Jones, that objection and request for a curative instruction might have some teeth. But they're gnawing on their own words right now.
I don't intend to give a curative instruction at this point, but as things develop, and especially if there are issues, further issues, then renew your request. And I would be inclined to do so right in the midst of
I think she knows
witness. And I am going to deal with Mr. Jones when he testifies.
That's understood.
Oh, I'm going to deal with him when he testifies. I'm going to do it.
Expect, as I discussed, Attorney Pattis, and I thought you were on board with it, I expected to canvass him on the issues that that were off limits.
The law of the case is not complicated, but I do think the court is, we will not object to a canvass.
And I did tell you that if there are issues, I will address contempt on the spot.
Yeah.
Well, I mean,
on the spot.
Well,
She's expecting
Pattis,
it.
I'm just telling you.
She's looking for golf balls in the forest,
now,
people.
I believe you said the last time that you can't remember your exact words, but something along the lines, I thought, that you weren't going to be able to control what he said. So I'm just laying it out here now, putting everybody on notice. So I know you'll do your job, Attorney Pattis, and explain to him what is off limits. All right, so we will
go over to Rumble, people.
Now just take a 5-minute recess, which is basically be a bathroom break, and we will have like 25 minutes before the lunch break.
All right, people. I'm ending it on Rumble. I'm ending it on YouTube. Going over to Rumble. You know where to go, people. 5, 3, 2, over to Rumble now, and remove it. Oh yeah.